What?
Oh, that was
Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the Appellate Division draw near, give your attendance, and you shall be heard. Be seated.
Good afternoon and welcome to the Appellate Division, First Department. We're going to begin with the call of the calendar, but let me advise you that we have more than 7 hours of requested argument time. So please know, as I always say, the court is familiar with your case, the briefs, the record, typically more than you wish we were. So please ask me for the time that you need, not the time that you want. As I assure you, the people at the end of the calendar don't want to be here until midnight. That said, People versus Tony, before I begin, I do want to give a hearty welcome to Central Park East High School and their teachers, Elizabeth Hala and Vivian Puhalovic. Did I get that right? I'm sorry. And I have the pronunciation out phonetically, and still I messed it up. Anyway, welcome, and to any of the students who may be aspiring law students in the future, you are most welcome, and I hope that nothing you see here today dissuades you from the All right, that said, People versus Tony Thames.
I will request 4 minutes and 1 minute for rebuttal.
Okay. 4 and 1 and 5. Castillo versus Cannon Point South. Okay. 4 and 1 and 5. Case of Liam. Do you, okay. You're the respondent? The respondent appellate. Okay, got it. I had a 0 indicator for you that you did not request time, and typically I don't grant time when you haven't asked for any ahead of time.
So Judge, I did request time. My co-appellate did not request time, and I believe that's why it says 0 here. But on my brief,
Got it, okay. Okay, we're going to do 4 and 1 and 5. Nazario versus ByteDance Limited. This is not one of those cases that needs short amount of time, it needs a lot of time. So give me your request, appellant first. Is that pro hac vici? Yes. Okay. That application is granted and welcome, sir. How much time would you like?
Your Honor, we would request 10 and 2, please.
Okay, 10 and 2.
Good afternoon, Your Honor. Seth Diamond from Bella on behalf of the plaintiff respondent. I'd like to introduce the court to Matthew Bergman, who has been granted pro hoc vice and request your permission to allow him to argue.
That application is granted and welcome to you, sir. How much time? 12 minutes. Thank you, gentlemen. Robinson versus Henderson.
Defendant responded.
How much time?
I'm not requesting time, Your Honor. To be submitted, assuming that plaintiff appellant is not here.
Okay, well, I don't see them here, and they're not going to be allowed to ask for time when they get here late if they haven't called. So we will take it on submission, and you can have a seat until the rest of the calendar is called before you leave. Okay? And thank you so much. 10839 Associates versus Big Apple E-Time LLC. Okay?
Good afternoon, Your Honor, for the respondent 5.
5 and 2 and 5. People versus Bridget Ascencio.
Good afternoon, Your Honor, appellate request 5 and 2.
Okay, 5 and 1 and 5. People versus Manuel Espinosa.
Good afternoon, Your Honor, on behalf of the appellant,
Okay? All right, 7 and 1 and 7. Seaton versus Babad. Submitted. Tower versus Structured Tone. Okay. 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 You have a cross appeal, correct? Okay. All right, 4 and 2, 4 for Jacobson, 4 and 2 for TGA and APCO, and 4 for you, sir. Okay. People versus Antonio Rodriguez. Submitted. An infant versus Paulino. Okay. 4 and 1 and 4. Terzukat versus Johnson. Submitted. People versus Baron Spruill. Okay. 6 and 2 and 7. Minkx versus Mount Sinai Health System. Okay. 4 and 1 and 5. People versus St. Robles. Submitted. Styles versus Sea Air Customhouse. How much? Okay. Respondent here?
Good afternoon, Your Honor, for Jonathan defendant, appellants, and
Okay. 6 and 2 for the both of you. All right. First case on the calendar, People versus Tony Thames.
See you.
You may proceed.
Thank you, Your Honor. Good afternoon, Lawrence Houseman. Line between those claims that are waived and those claims that are not. And that is where one of the two places where the court went off script from the CJI in, I think, a very troubling manner. The other place where the court went off script from the CJI and also, I think, created problems for the validity of this waiver is when the court said, you've been asked to waive your right to appeal. And then one sentence later says, on that appeal, you would have the right to counsel and poor person's relief. So the court's directly tying that right to counsel and poor person relief to the waived appeal as opposed to the, the narrower appeal that survives a waiver. And I think
Waiver cure the items you have complained of?
In these circumstances, no. And I think the main reason, there's two reasons for that.
Waiver inaccurate?
I think the written waiver was accurate, but the problem with the written waiver,
Doesn't People v. Thomas require and say that the court has to assess whether the waiver is appropriate based on the entirety of the record, not just the oral colloquy, but also the written waiver?
absolutely, Your Honor. This court, and just 2 days ago, and repeatedly has said that you should rely a lot less on the waiver when the court doesn't elicit that the defendant read the waiver or understood. Now, it's true that the court elicits that the waiver was discussed and that it was signed, but I think the words, what this court prefers in the record to give much meaning to the written waiver is for there to be a record that Mr. Thames read the waiver and understood the waiver. And I think there's a final problem with the waiver, but perhaps I'll save that for rebuttal because I would like to get to the merits, because I'm hoping that you agree with me as to the reasons to get to the merits. But in this case, this was not a random act of violence. This was a crime that was motivated by fear. And there was well-founded fear here. As counsel made a very strong record at sentencing, the decedent in this case had brutally strangled 2 women and left them naked in the stairwell of the very building in front of which this crime happened.
And the defendant was concerned for his wife and his child, correct?
Correct. And I'm not saying, we're not saying here, and sentencing counsel is very clear, we're not saying it was justified. But we are saying it's relevant to what sentence was appropriate. And even the court recognized that it was an extenuating fact, and the court said, well, the parties have taken this into account. But it's certainly my view, and I hope it's the court's view, that a sentence 8 years above the minimum did not adequately take into account this extenuating circumstance. It's also in the context of an individual for whom this act of violence, our client's act of violence, was very aberrational. He's now a 45-year-old father, and he had no prior history of violence, and a very sporadic criminal history at that. He had one prior grand larceny, felony grand larceny, and then when he was a teenager, he had a drug offense.
You can tell us more about that on rebuttal.
Thank you, Your Honor.
John Cheever for the people. Good afternoon. The defendant validly waived his right to...
Also, picking up on what your friend was just saying, didn't the court consider all those things in sentencing the defendant?
Absolutely. Explicitly. They did.
It was talked about on the record, and the court addressed it.
Yes, it was. That's right. The defendant validly waived his right to appeal the excessiveness of his sentence, 13 years in prison for fatally shooting Gerard Watkins while the defendant was still on probation for his second felony is not excessive. The sentencing court followed New York's model appeal waiver colloquy essentially verbatim. It's also clear that counsel was extensively involved in the decision to waive the defendant's appellate rights, because the defendant said on the record that he had discussed the waiver with counsel not once, not twice, but 3 different times. And to the extent there was any ambiguity, it was cured by the written waiver, which was signed by the defendant and his attorney, which explicitly relinquished the right to bring the exact claim he now brings before this court. Defendant's sentence of 13 years prison for manslaughter in the first degree, when he faced a minimum of 15 years and up to 25 years for murder in the second degree, was completely appropriate. The defendant claims, without citing evidence, that he was fearful of the man that he killed, but that did not give him the right to shoot him in the head and end his life. While any period of incarceration is a heavy consequence, defendant's punishment has to be considered in light of the damage that he caused, and Gerard Watkins is never coming home. Defendant's own attorney added at his sentencing factual background, but admitted that the killing was unprovoked. It's the word that they used. As the decedent's sister eloquently put it, the victim was my protector, my friend, the person I called on when I needed help, my big brother. You took happiness away from his fiancée, murdering him on her birthday and changing her life forever. You took a father away from his kids. 13 years is fair. The waiver is valid. We ask that you affirm.
Thank you.
Counsel, why is 13 years not fair?
Again, Your Honor, I think it's because of the extraordinary circumstances here. My adversary mentioned or took the position that we didn't provide evidence of the complainant's violence, but counsel actually pointed specifically to the very proceeding where the complainant and the facts of the sentencing that the complainant received. And Your Honors can Google the complainant's name or check court records. He did indeed kill, brutally strangled.
Well, that may be true. What,
Mm-hmm.
what statement would that be saying if we just accepted that because someone was convicted of a heinous crime, that now you're justified and reasonable in your fear when there's nothing imminent?
Well, I think that's a good question, and I think it goes to the point of what we're saying, which is it's not justified, but it is powerful mitigating evidence. And I point, a case we relied on, although there are not a lot of facts in the opinion from this court, People versus Flores, is a very similar, and I think some of the justices on this panel were on that case, so you may be familiar with it. It's a very similar situation where crime was not justified. It was an imperfect justification, but the complainant, Mr. Flores feared the decedent. And that's a case too where the court even mentioned it in the record there too. The trial court was concerned about the extenuating circumstances and imposed a 15-year sentence. And this court reduced that sentence to 11 years. And so what I think I'm saying is that 13 years is a very sentence for a very typical manslaughter, plea down from a homicide. But these are very unique extenuating circumstances. And I think a sentence that's 8 years above the minimum for...
Sadly, these circumstances are not that unique. We have a great many people in our city who fear dangerous people in their neighborhoods, right? We can't sanction vigilantism. But I understand your argument. We've got your record and the briefs.
Thank you, Your Honors.
Castillo versus Cannon Point South. You may proceed.
If I may please the court, thank you for your time. This incident concerns a trip and fall case where a plaintiff who was an employee in a garage which was rented from my client's building. Plaintiff tripped and fell while working, and his sole remedy in this case is workers' compensation. They're trying to find a different path to go after an entity which had no contractual liability or responsibility to maintain a metal grate, which plaintiff claims he tripped over. Here, under the contract and the lease,
You're saying the owner doesn't have a responsibility to keep the premises safe?
No, Your Honor, I'm saying under the lease, they had abdicated that to the tenant. That they are an out-of-possession landlord who are not in the garage and running it from day to day. The garage is under the complete control of a tenant who's responsible under the lease to maintain the metal grate that's at issue.
Isn't there evidence in the record that they assumed a responsibility by dealing with the grate, notwithstanding a lease provision that would impose it on the garage?
No, Your Honor, there is nothing in the facts. There's two incidents that's highlighted in the facts where one speaks to a incident that happened 10 years before where one of the garage tenants met somebody who said that they were working for the building and nothing to do, and they were going to work on a grate. That's one incident 10 years before.
We're talking about the work done that morning.
There was no record of any work being done that morning.
No one lifted the grate that morning to clean it?
No, Your Honor.
That's what the record shows.
Yes, Your Honor. The two individuals who were there, the plaintiff himself, his coworker, Mr. Concepcion, and the building superintendent, they all testified there was no work done at that location. The sole issue that they have raised is a hearsay argument from a person who doesn't even work there. They identified Mr. Velez, who there's no record of him working there, claiming that he saw something. There's nothing to corroborate that. The building's maintenance records, the testimony from the witnesses that were there, all, including the plaintiff himself, no work was done on the metal grate that day. So there is no duty here to maintain. Moreover, even if there was any claim that there was some sort of a duty.
There is no Ronald Velez, there's no Angel Velez. That name and that person
There is a,
just came out of the sky.
there's a Mr. Velez that is associated, but he wasn't even working there that day. He's a manager for various different places. He wasn't there. The plaintiff testified he wasn't there. Mr. Concepcion, his coworker who was there, testified he wasn't there. The building's maintenance records all showed that no work was done in this location, and the building did not have an obligation, nor did it ever do work on the metal grate. The only time that they talk about it is one incident where a year before, on the street level, when one of the porters was blowing the leaves, they went into the metal grate that was up top. And they complained to the building super that there was leaves there, and because of that special circumstance, he used a leaf blower to clean it out, never lifted the grate. There's no record of that in any way. Moreover, even if there was an argument there was some sort of a duty, there was no defect according to the evidence and the testimonies given. Mr. Concepcion, who was there, and the plaintiff themselves said they went over back and forth over this metal grate multiple times. Mr. Concepcion testified he was there, walked over 5 minutes before. This grate was never lifted, wasn't raised at all. Plaintiff claims that some between 5 minutes from Mr. Concepcion's last walking over it and him walking over the grate moved
This
somehow.
grate extends over a wide swath of space, correct?
Yes, Your Honor.
So are you suggesting that there was testimony that the path that was traversed back and forth over this grate was over the exact same location?
Yes, Your Honor. There's only one way to move the cars in and out of the garage. And they-
Counsel, you just said that it is a wide space, right? So perhaps he walked on the right-hand side on one occasion and on the left-hand side on the other, is my point. But you'll have time on rebuttal.
Thank you, Your Honor.
Thank you, Your Honor. Good afternoon. Jason Levine for the plaintiff respondent. Just picking up on the questions that the panel posed with respect to this Mr. Velez. He's actually the garage manager, and it's based on plaintiff's testimony at page 114 of the record. He was informed by Mr. Velez that there was a cleaning done by building employees that morning of the incident, and that they had not left the grate in the proper position. So in addition to that evidence, we also have the evidence that the motion court laid out in its order, which shows that the defendants failed to make a prima facie case that they lacked any duty of care to maintain the property in a safe condition, notwithstanding the provisions of the lease. We have Mr. Concepcion's testimony that he understood that it was the building defendant's responsibility to remove the grate to access the drain. We have the building superintendent's affidavit, which he admittedly, about a year prior, removed the grate, albeit not the same one, but one at the top of the garage to do some cleaning. And we also have the post-incident repairs that were done, which shows, it raised an issue of fact that's the control by the building defendants. Here, this was a complete redo, a repaving, the entire drain, everything was redone. Again, all these factors taken into account shows that it's certainly an issue of fact raised by the defendant's own proof in support of their motion, which does not establish the absence of a duty of care. In addition, for the other reasons set forth in the court's order, issues of fact as to whether this constitutes a dangerous condition. Also, with respect to the issue of notice.
Well, counsel, how does the issue of spoliation play a role here, particularly when they never appealed the spoliation order?
Right.
Right?
Exactly right. They didn't appeal it. It remains, there's still an adverse inference charge now, instruction to be given at trial based upon this, frankly unexplained, failure. After all the scheduling was done, there were certain discovery orders that were scheduled, to have this plaintiff's expert inspect it. So I think the court was, certainly well within its discretion under these circumstances, as, the court pointed out in these specific facts, to make that determination on notice, because the plaintiff's expert was precluded from inspecting this drain, granted be a couple of years later, but still completely precluded from making any opinion whatsoever on the condition and or notice. So unless the court has any further questions, we'll rest on the arguments in our brief.
Thank you.
Thank you, Your Honor.
Your Honor, with regards to Mr. Velez, there's two different names given. The actual individual, Mr. Velez, was not working there. He's just, imagine, I'm not denying that there is a Mr. Velez, but he was not there. And the people who were there indicated that there was no work being done on the metal grate. The superintendent who's in charge of the work, with regards to the maintenance of the building and any work that's done, it's gone through his approval, noted there was no record. There's a clear record maintained maintenance logs. None of them show any work being done and ever being done on this metal grate before this incident.
Counsel, based on the building records, didn't the superintendent testify or give an affidavit to the effect that they only reflect actual complaints that are recorded, but after March of 2019, the accident took place in April of 2019, that it is conceivable that the record is incomplete in terms of supporting your claim that no work was done that day?
No, Your Honor, it's not simply only the complaints, any other issue, it includes complaints on any work being done. All work would have to be approved by him. He indicated none of his workers are allowed to do any of those work because of Local 32 rules, and no work was ever done. No record of that exists. With regards,
Thank you.
Thank you, Your Honor.
In the matter of Liam.
Let me know when, Justice. Good afternoon, Justices, and may it please the Court. My name is Michael Weinstein from the Neighborhood Defender Service of Harlem, and we represent the respondent appellant, Ms. J. Up until the point that the family court issued its disposition order, family court was working. We know that family court is a court of rehabilitation. And what we see in the record within this proceeding is that from the inception of this case related back to the abuse petition back in 2018, through the point where disposition entered, Ms. J showed significant improvement in her attendance and services, her engagement in services, in the visitation. This is what our—
Is the test significant improvement? Is that the standard?
It is, well, it's the purpose of the family court to rehabilitate the families.
Yes, of course, but the standard in terms of whether termination of parental rights is appropriate, it's not whether she's made significant improvement, correct?
So I think they're correct, and there are two parts to that, Justice. The first part is the termination fact-finding phase, where an agency has to prove diligent efforts as to permanent neglect, which was the charge here. The second part at disposition, which the Family Court Act says a court at that point in time can enact the termination order, grant a suspended judgment, or to dismiss the proceedings. And the second inquiry there is the best interest of the child. But from matter of Star Leslie W.
So tell me how a child who hasn't seen their parents for months and months and months at a time, how that it is in the child's best interest to not let this child be adopted by the only caretaker the child has had for years, and who is ready, willing, and able to provide this child with a loving and stable home.
Well, we know from the Supreme Court of the United States that terminating a parent's right is the equivalent of—
Counsel, I know that.
Counsel, she was giving visits twice each week. In 2020, she only made 9 visits, and in 2021, she made 1 visit.
And it's important to take it into context, Justice, there's the visits at the agency which were not occurring from April of 2020 through, I believe it was November of 2021, I'm sorry, into May 2021. But there were still visits occurring at Gabby, the dyadic therapy. And all reports of all visits that have occurred are that those visits have gone well. We know from the Court of Appeals in matter of Star Leslie W. that a court can—
And again, that's not the standard. The issue is, has this parent demonstrated that she has fulfilled the plan for her reunification with her child? And has she taken all of the necessary steps to provide that child with a stable home, right? And I know that she got an apartment, et cetera. I recognize that this record shows that your client did show significant improvement. But that's not the bottom line issue, right?
Respectfully, the Court of Appeals has said that a suspended judgment is an opportunity to give a parent a second chance where such significant improvement has occurred. And that's precisely what we have here.
What about the chance for the child to
The
have a life, to be able to have a future that is secure and assured?
The suspended judgment is for a period of a year, and it can be terminated at any point if there's noncompliance. Particularly considering that we are here on appeal now, if a suspended judgment had been granted, perhaps the period of termination would have been even shorter. But I'll save everything for the rebuttal.
Good afternoon. May it please the court, Shireen Nothenberg, on behalf of the subject child. And I'd like to pull up some of the ideas that were percolating before this court as the questioning began, one of which is the significant progress. And while I entirely endorse this court's concern that significant progress is not the standard, I'd also like to note that there wasn't, in fact, significant progress. I would note that in 2023, in November and December of 2023, this mother made no visits. In addition, in 2023, the mother still claimed that her house was not ready to be inspected. In 2018, she also said that her house wasn't ready to be inspected and did not let the agency inspect.
And counsel, though she did complete some services, she didn't plan for the child's future.
Let's talk about what does it mean to plan for a child's future? Wouldn't it mean to actually spend time with your child? Wouldn't it mean developing a relationship with your child? And what I find extremely upsetting about this case is the constant discussion about how mother was actually engaged in Gabby services. Let me be clear. In 2021, there were 52 weeks like there are in every year. And in 2021, she made exactly 8 of the visits to Gabby. 8. You know how many she made to the agency? 1. So she saw her child 9 times. Ask yourself, how does one develop a relationship with your child? And that has got to be the minimum for planning for the return of your child, to see the child, to develop a relationship with the child.
Counsel, did this mother ever gain insight into the reasons why Liam was placed into foster care?
There's no indication of that whatsoever. There's no indication that she also gained any insight about the necessity of actually seeing her child and spending time with her child. There's no indication she understood the necessity.
And to date, both parents continue to profess that neither one of them is responsible for their infant child's broken bones.
Nope. And it was just one bone. I'll concede that 100% was only one bone, but that is one bone on a 5-month-old.
And Liam is doing well.
He's
foster care. He's in the Success Academy.
And not only that, but he's grown up in foster care, and that shouldn't be allowed in this day and age. Honestly, he has been in care since he was 5 months old. This mother has never had an unsupervised visit up until his birthday about a year ago. And to this day, was not engaged in her services or her visits in any regular fashion. It is time for this child to have a home that he considers his for good. That's what he wishes, and that's what I hope this court will grant him today.
And just to, of concern to me was that toward the tail end of his visits with his father, the child starts reporting that the father is being mean to him and he doesn't want to spend time with them.
And in fact, the reports are that the father is in fact brusque with the child. When the child had not seen dad because the father had not shown up for visits, then the child was reticent about hugging him. And the father said, "What's wrong? Do you have an attitude? You have an attitude?"
Counsel, and this foster mother was willing to allow for visits, wasn't she?
Yes, she was. Yes, she was.
And it's my understanding that the foster mother is not adverse to a relationship with the biological parents, correct?
That's my understanding as well.
So they would have some connection.
I can't speak to that at this point. There's no way I could speak to that, but all I can say is what my client desires, and that is to know that the home he's been in for years and years will remain his home. And that's what I hope this court will allow for. Thank you so much.
Counsel?
Just, let me know when, Justices. Oh,
Go ahead.
Okay. So,
I'm giving you her leftover few seconds.
oh, I appreciate that. Thank you. Just to address your points, Justice Shulman and Justice Rosado, Yes, that is what the foster parent testified to in the proceeding, but in the over a year since the conclusion of the proceeding, not once has anyone reached out to Ms. J to arrange for any type of contact, despite that assertion being made. So
Has Ms. J ever asked
she's
for
never.
those visits to occur with the foster mother's consent?
I do not personally know if she's called the foster care agency, but she doesn't have the foster parents' information.
Counsel, wouldn't you think
Yes,
it would
Justice.
be important, among other future planning, to show the appropriate agencies a safe and warm home for the child? Yet it was repeatedly refused to have access to look at where the child could potentially live with your client.
I think there are I think it's complicated. There are obviously conversations that I had with my client that limited certain things I can say, but if you look at, let me know if I can have a moment to answer. If you look within the record, there are numerous examples brought up in actually all of counsel's brief concerning the respondent father's behavior towards Ms. J. And that certainly had an impact while he was there to allow her to have the agency come and visit.
Thank you.
Thank you.
Nazario versus ByteDance Limited. May
May
proceed.
it please the court. Timothy Hester of Covington and Burling on behalf of the social media defendants. The plaintiff's claim challenges algorithms that Instagram and TikTok use to organize, prioritize, and present third-party content to their users. She alleges that those algorithms delivered harmful content to her son that caused his death. Section 230 of the Communications Decency Act bars.
Sir, I'm sorry, I don't want to cut you off once you get too far into Section 230. Could we start with the state law issues?
Yes, Your Honor.
Particularly the issue of whether the social media platform application or the algorithms that drive them are quote-unquote products within the meaning of New York State products liability law?
Well, Your Honor, I would answer that in two parts. First of all, these are services, not products, and there's a general recognition in the products liability law domain that products liability applies to tangible products, not intangibles like these services. But I submit the court doesn't need to reach that because there's a fundamental threshold issue under state law of proximate causation. And the Supreme Court held that the subway operator defendants should be dismissed for lack of proximate causation. Court held, quote, in the record at 21, some activities are so obviously fraught with danger that in such circumstances the actor's conduct is an intervening and superseding event which severs any causal nexus. And the plaintiff did not appeal the Supreme Court's ruling dismissing the subway operator defendants for lack of proximate cause. And that
I think
ruling,
MTA and the social media defendants are similarly situated.
they're not similarly situated factually, Your Honor, but there's, in relation to any of these state law tort claims, there's a requirement of proximate causation. And the proximate causation ruling.
Well, I mean, here the plaintiff is saying that part of their theory is that insofar as the algorithm sends these harmful videos to minors that we know from our social sciences and our neuroscience research that young men in particular are quite impressionable. And so it seems to me that the two defendants here are in completely different stands. One is a passive participant. MTA just happens to provide the train that this young man got on top of. And the social media defendants were, according to the plaintiffs, and we haven't had discovery, so I don't know whether there's any truth to it, this child was being sent and his feed was being infiltrated by subway surfing videos that he didn't solicit.
Yes, Your Honor.
That's the claim.
Yes, Your Honor. But the doctrine of intervening cause breaks that causal chain. So where the holding of the Supreme Court here is that the son's own illegal and reckless conduct was the sole proximate cause, the causation, whether it's by the social media defendants or by the subway operator defendants, is broken. That causal chain is broken as a matter of the doctrine of intervening cause.
What case has ever been litigated that explores the issue I'm talking about with the targeting of minors, which we know exists. We have lawsuits going on right now in California with the same thing. So explain why that difference should not at least entitle these plaintiffs to some discovery in order to explore whether there was indeed an active campaign at the time to make sure that anyone who fit the algorithm profile of young male, perhaps young urban male in New York City, why that would not be something that the plaintiffs should be able to at least get some discovery on, and perhaps we come back here and your arguments are a lot stronger because we've got the data to show that he searched on his own, for instance.
The issues here are different from the ones that are being litigated elsewhere in the country because there's a very specific allegation of a very specific harm. There's an allegation of a very specific harm from subway surfing that led to the boy's death. So in that circumstance, what you have, it's different from a question of, is there addiction to social media? This is a specific harm that's alleged to have arisen from exposure to a certain kind of conduct.
Why does this not fall into addiction to social media? I mean, that's the whole point, that these kids can't stop looking at these videos.
But no, I think it's narrower than that, Your Honor. The allegation is harm from a certain kind of content that led to his death. So you have a very specific harm, and you have a finding already, binding on the plaintiff, that the boy was the sole proximate cause. When you have sole proximate...
Vis-a-vis the MTA.
Well, vis-a-vis any tort claim in state court.
Well, that's the question that we're here to decide,
Yes.
right? Okay.
Well, I got off on the state tort issues, but if I could go back to...
Go right ahead.
Because I did want to make sure we cover that as well.
That was very subtle, the way you looked at me.
Subtle, I hope. So Section 230 of the Communications Decency Act bars these claims based on the algorithms and the allegations that content was being delivered to the son that led to his death. The statute provides immunity for publishing activities such as the use of algorithms that connect users with third-party content. And we see this in the Force v. Facebook case out of the Second Circuit, where the court held that Section 230 applies to algorithms that, quote, suggested third-party content.
What about the Third Circuit decision in Anderson, which has a fact pattern that's a little closer to the one at bar?
Well, I think the Third Circuit decision in Anderson, first of all, is an outlier. And I think it is at odds with Force v. Facebook. It's at odds with the more recent decision in MPV Meta out of the Fourth Circuit, holding that, quote, acts of arranging and sorting content are integral to the function of publishing. And that's a case that rejected, again, a theory that algorithms had directed content that led to harm. So we have the Fourth Circuit, we have the Second Circuit, we have the Ninth Circuit in the Dyroff case, saying algorithms are tools meant to facilitate the communication and content of others. So you have multiple circuits that have gone down this path holding that Section 230 applies to tools that are used to connect users with content. Now, even if
There's something, I have to say that as I read through a lot of this case law, it just seemed to me perverse that a statute that was enacted to protect children from sexually explicit content online has now been turned on its head, so that that very same statute, which was intended to protect children, is now shielding social media companies from their acts of utilizing algorithms to keep these kids on these social media platforms?
Well, respectfully, Your Honor, I don't think it's shielding. I think the Congress recognized, made a judgment 20 years ago or more, that there was a judgment to be made about how the internet would grow, and that if social media platforms were going to be responsible for editing and monitoring the content being published by third parties, the internet would not grow. That was a choice Congress made.
I agree. But that statute was enacted some 30 years ago now. And the internet has exploded and changed the way we all live. And social media and algorithms and AI change every 3 months, right? So why is it inappropriate for the courts to continue to revisit the application of these algorithms in light of the fact that they keep changing and they keep on advancing and they are getting better and better and better at targeting who they want to target? Why is that not an appropriate area for discovery at the very least?
Because, Your Honor, the Congress is well aware of the way social media.
Yeah, well, we know Congress is not exactly functional now, so that doesn't help society in dealing with this ever-growing issue, right? So it's left to the courts.
Sorry, Your Honor, I didn't mean to interrupt.
Right?
The statute exists, and I would submit that the Force Department's decision in Patterson from July 2025 is persuasive authority on the identical legal issue that's presented here, and we respectfully submit the court should follow that decision. It rejected the identical claim being made here, that algorithms that delivered harmful and unwanted conduct somehow were outside the scope of Section 230, and the court held squarely that that claim was barred on the pleadings under Section 230 as an attack on the publishing activity of social media platforms. So Patterson, I think, is an answer right on point.
My colleague has a question.
I'll keep you on 230 this time. Given the backdrop of the statute that you and Justice Manzanet Daniels just talked about, the sort of protecting editorial judgment, how does the use of the algorithm here factor in? Has the editorial judgment, so to speak, been ceded or delegated to the algorithm such that that concern about protecting the integrity of human editorial judgment, that concern has sort of been obviated?
No, I think there's two parts of publishing activity. One part is the fundamental one. Are you going to let something stay on your service or not? But there's another kind of publishing activity, which is really at the heart of this issue, the activity that connects users with content. Just like a newspaper decides, I'm going to run a story on the front page because this is the one that my users want to read. Same thing in the social media context. It's obviously an enormous scale, but it's the same issue. The social media companies have tools to connect content with users, and Patterson recognized that it's impossible for the internet to operate without some mechanism to allow users to connect with the content that's of interest to them. There's 3 billion users a day around the world on Facebook and Instagram, as an example.
Are you of the opinion that social media companies are entitled to target their activities toward minors?
Your Honor,
because I think that all of your arguments with regard to, the freedom of speech and the free access of information, those arguments are not arguments that offend most of us, right? But when we're thinking about our children being targeted by this information, is there no room for saying that should be the line, that these algorithms should not be allowed to target minors?
Well, Your Honor, the word targeting is loaded in a way, but
well, the algorithms are sending these videos to people in their profile that they think will like it. And I suspect that if we do a hearing on what that algorithm actually was, specifically to the subway surfing, I'd be very interested to see what were the factors of that algorithm that made those particular videos go to whom and why.
But the broader point is the algorithms connect users with content.
I get that.
And
my question is, should social media companies be allowed to allow their algorithms to go to minors?
Congress has made the choice that the answer
No,
is yes.
Congress did not make that choice, because when this statute was enacted, these algorithms didn't exist.
But there was.
Go ahead, you have a question.
Counsel, if they were directly responsible for the content, that would be an exception to 230, correct?
That's absolutely right, Your Honor.
Fair enough. So the notion that that they put in an incentive structure, as Justice Mazanet Daniel raises, to somehow force these videos onto minors. An incentive structure is not the content. These are, and again, I'm not a internet maven, but all the bells and whistles that go in, like push notifications and et cetera, et cetera. It's not a question of the New York Times putting a lead story on the right-hand column above the fold. We're talking about all the other stuff that goes into how these videos are constantly bombarding these minors. That's a very different scenario. In a sense, to borrow your friend's terminology in their briefs, like co-creating, almost being more directly involved. That's one part to make a distinction here. The second part is, it's interesting that they're putting these videos to the kids with Nike ads, for example, that promote balaclavas, that help hide the identities of these so-called surfers, I guess, to avoid arrest for doing this. So there's some connection between the advertisement revenue, TikTok and Meta getting all this money coming in, and how they push these videos through the various algorithms. That's very different than publishing and editorializing the scenario. Would you agree or disagree?
I don't fully agree with you, Your Honor, on this, because I go back to the Shumeli case from 2011 out of the Court of Appeals, which I think is actually a very important decision on the scope of Section 230. And in Shumeli, the defendant took specific actions to draw readers' attention to a third party's defamatory post. They moved the post up onto their website in an aggressive way to bring attention to it. It's in the early days before algorithms were really active, but it was the same concept. Actions taken by the website operator to bring content to the attention of users.
Counsel, do we know what the intended hope or desire is from the social media companies in specifically targeting minors with this type of video?
Well, Your Honor.
Isn't it clicks? Isn't it the hopes that they would record and upload?
No, Your Honor, first of all, there's content moderation policies that all of these social media companies have, TikTok and Instagram and everyone else, among other things, to prevent or bar violent or unduly dangerous activity, but it's hard to weed it out.
You're talking about unduly dangerous. You're riding on top of a subway. I don't understand how it could get more dangerous.
But Your Honor, it goes to this point. There's a difference between, they have policies that do not try to promote this content. They're not trying to promote this kind of.
But Counsel, what happens in essence is that the algorithm targets a specific audience. And if they're successful, right, in targeting that audience, then the social media companies get more uploads. They get more clicks. It's about clicks, isn't it?
Not entirely right, Your Honor. I would say the objective is to make a positive experience for users. That's what the social media companies are looking for. And you can't create a positive experience without connecting users with the content that's of interest to them. But just to finish, I know I'm on my red light, Your Honor.
No, you have been on your red light for about 5 minutes, so you'll have time on rebuttal. Rebuttal.
May it please the court, Matthew Bergman on behalf of the plaintiff respondent. What did Congress think about? What was Congress's objective? And we quote from Section 230, to maximize user control over what information is received by individuals, families, and schools who use the internet. 4, to empower parents to restrict their children's access to objectionable or inappropriate online material. And yet, for some reason, we hear the argument that an algorithm that is designed to addict kids, showing them not what they want to see, but what they can't look away from, is somehow immune from any state law liability. We respectfully submit that that is contrary to the Court of Appeals holding in Chamonix, and moreover, contrary to the basic principles of New York tort law.
Sir, is algorithm essentially a formula?
It is, Your Honor, and an algorithm can be, it's a shorthand for a lot of things. What is important here is that we explicitly allege on page 76, on paragraph 76 of our complaint, and the Supreme Court explicitly found that these are not simply algorithms geared toward giving people what they want to see or what they're looking for. The subway surfing videos at this issue, as alleged, and must be taken as true by this court at this juncture in the proceedings, are that Mr. Nazario was not looking for this material. He was being fed it in order to maximize his engagement
Counsel,
and the profits and the advertising derived therefrom. Yes.
I want to ask you, what's the real issue? Is it that a minor was targeted, or is it the message that was delivered to that targeted minor?
Well, Your Honor, the suggestion that because content is somehow involved in the chain of causation, the case is ipso facto immunized under Section 230 is a misreading of Chamonix and the controlling. Yes, of course. So the issue here is that the algorithm was designed to addict Zachary Nazario by showing him material that the defendants knew was going to result in subway surfing.
So here, unfortunately, was subway surfing. Had it been an addiction to food, would we be here?
Well, I'm in trial with counsel's co-counsel in Los Angeles, and there were serious cases involving serious mental health harms. There are other harms that can result and do result from social media, including addiction, eating disorders, body dysmorphia, and the like. The scenario here is, of course, this is the most egregious harm conceivable that any parent can envision. And I think it's important to discuss to respond to counsel.
You made a statement earlier that in a very conclusory fashion equates the exposure to the video with proximate cause for his actions. How do you get there?
Well, we get there because, first of all, we specifically allege.
Because a bunch of other kids saw that video too and didn't do.
Well, sadly, Your Honor, as recently as a few.
So my point is, how do you, just receiving it by itself, is that enough to establish the proximate cause?
Well, a lot of people are given, a lot of people are exposed to asbestos, and only some of them develop mesothelioma. So I think that in this, I mean.
Counsel, really? That's your analogy?
My analogy is that not every, well, first of all, Justice, sadly, many children continue to die of subway surfing as recently as 3 months ago. So this is an epidemic in this community, as we've alleged in our pleadings.
But I hear asbestos. Oh, I'm sorry.
Go ahead.
No.
I understand why you raised asbestos, but asbestos was in a product sold in which users were exposed. And as my colleague asked your friend earlier, the internet videos being provided to Zachary here were free.
Well, no,
just bear with me.
I'm sorry,
Judge. Free.
Yes.
Asbestos is a fiber. It's a mineral. It's tangible. It was in products. The internet is not tangible. It's an intangible. So then how do you make it fit with the question my colleague raised earlier?
Well, as the Court of Appeals has instructed us in Terwilliger, there's a multifaceted analysis, and whether or not something is or not tangible is not talismanic of whether or not it is a product or not. One looks at a number of factors. Clearly, it does occupy the bits. It occupies computer space on a laptop. It is tactile. It's mass produced. Based on the Terwilliger factors and based on what's alleged, it is manifestly appropriate to determine that it could be a product, or that we should have the opportunity to do that. As set forth in Section 19 of the Third Restatement of Torts, not everything that is tangible is a product, or not everything that is intangible is a product. Electricity, for example, has been deemed a product. Software has been deemed a product. So at this very early juncture of the pre-answer stage, we believe it's, under Terwilliger, we've alleged adequate facts.
Sir, I have a hypothetical for you. We'll take X, okay? X is a publisher. X publishes a book about subway surfing, and it advertises it, and it is specifically designed and published with a teenage audience in mind. The publisher then follows that up with a monthly periodical, and that they, unsolicited, they sell to teenagers throughout the country. I'm sorry, they send to teenagers throughout the country. They then double down and they come up with a weekly newsletter about subway surfing. Again, unsolicited, send that to material to youth throughout the United States. Someone reads one of those periodicals and engages in subway surfing and is injured or killed. Would that publisher of those three types of periodicals, would they be subject to products liability?
Absolutely not, Your Honor. Absolutely not.
And so what is the difference between the publisher in my hypothetical and the algorithm here that is, as I see it, the vehicle that is driving in a very sophisticated way the information or content to youth?
Because the algorithm is designed to addict young people. It's designed knowingly to take advantage of the underdeveloped frontal cortex of young people, and the design of the challenge. The architecture of the challenge is something that's designed by TikTok. What goes into the challenge might be third party, but the challenge architecture, as we've set forth in the complaint, is illustrated. And secondly, it is designed to take advantage of the need of adolescents for social acclimation, and you bombard a 15-year-old boy in the throes of puberty with this material, and you laud it, and you addict him to it, and then you suggest that this is a safe and fun activity. That could not be further away from traditional publishing activity that the Court of Appeals in Chamonix recognized was subject to Section 230 immunity. I mean, as the Supreme Court held, Section 230 prevents imposing tort liability on companies that serve as intermediaries for other parties' potentially injurious messages. We're not talking about an intermediary here. We're talking about affirmatively co-creating the content. We're talking about seeding it with advertisements. We're talking about repeatedly, and as we set forth on paragraphs 187 and 188 of the complaint, the defendants actually know that kids are going to act upon these subway surfing videos, and in the horrible way that occurred here.
Counsel, does the finding in favor of the MTA on the issue of proximate cause or superseding actions on the part of Zachary, that doesn't affect the social media defendant?
We believe not, Your Honor.
They claim it does. They claim that ruling.
Yeah, and I think the key language is in the Dumbasi case, where a decedent's act is a superseding cause of whether or not, or whether it is a normal consequence of the situation created by a defendant, are typically questions to be determined by the trier of fact. And then the Supreme Court, relying on Collins, said, however, the issue of proximate cause may be decided as a matter of law only where one conclusion may be made from the established facts. So what we need to look at is, what is the situation created by the defendant? In the case of the transit defendants, the situation created by the defendant was not locking the doors, not having a warning, not having extra staff, and not having a guardware. That is a separate situation. Here, the situation created by the defendant was addicting a 15-year-old child in the throes of puberty, in the need of social acclimation to its product, in affirmatively encouraging that person to engage in subway surfing, as we set forth, knowing that they would act upon that.
So is that, sir, what distinguishes the proximate cause analysis versus a social media defendant against the premises owner and management companies in the elevator surfing cases?
Yes, I believe it does, Your Honor, and certainly, you know, I mean, the overarching principle, as this court is well aware, is that issues of causation are factual issues to be determined by the trier of fact. There is only a very narrow exception where only one conclusion may be drawn from the established facts. I would respectfully submit that the materials that we've submitted, the complaints that we've alleged, and in particular paragraphs 187 and 188 of the complaint, set forth an alternative explanation that Zachary was not aware of subway surfing. He was gulled and lulled into believing that this was a safe activity. He saw other people doing it and having fun, and saw people developing social acclaim and social acclamation.
So I apologize in advance if I missed this in your pleadings, but do you plead anywhere that either the young man here, the young boy, I should say, and or the girlfriend or anyone else recorded this incident?
We do not, Your Honor. We do not believe that the actual incident was recorded. Unless there are any other questions, Your Honor, yes,
Sir,
please, go ahead.
Can you distinguish the Fourth Department's decision, the majority's decision in Patterson, or are you asking us to go in a different direction?
I'm distinguishing it, Your Honor. I believe that the Fourth Department majority, begins with the faulty premise that Section 230 creates a federal immunity to any cause of action that would make a service provider liable for information originating with a third party. That is directly contrary to the Court of Appeals' very thorough, albeit early analysis of Section 230 in Chaminelli, that one has to look at what the cause of action is, that Section 230 immunizes service providers from liability for third-party content whenever such liability depends on characterizing the provider as a publisher or speaker. And as the Supreme Court held in this case, we do not, and indeed we affirmatively say that we're not saying that they should have taken down a single bit of content. We are not seeking liability based on traditional publisher activity, but rather basic common law negligence and product liability under New York law.
Thank you.
Thank you, Your Honor.
We peppered you so much, I'm giving you an extra minute.
Thank you, Your Honor. I want to go back to Section 230. In Patterson, the court held that Section 230 immunity applies to algorithms, quote, even if the content is not actively sought by the user. That's 244 AD 3rd at 35.
I'm aware of these holdings, and I keep asking you whether there should be a difference for a minor. And you seem to say no, that the social media companies should be allowed to treat minors the same way we treat adults, knowing what we know about minors. That continues to be your position?
Yes, it is, Your Honor. Under Patterson, I think that is the position. There isn't an analytical distinction drawn in.
Well, Patterson didn't discuss that, did they?
It involves the question of whether publishing activity is immune under Section 230.
Yes, but it did not involve a minor. The issue of whether algorithms should be used against minors is not something that has been explored. If there's a case that does, please tell me which one it is.
All of the case law.
Children. I'm being very clear because that's where I am laser focused on the impact and the use of these algorithms on minors, because I don't think that minors and adults stand in the same position.
But, Your Honor, I understand the point the court's making, but Section 230 immunity doesn't turn on the age of the user. It turns on the nature of the publishing activity engaged in by the social media service. And here,
And again, I say to you, Section 230 was enacted over 25 years ago.
yes, Your Honor.
So the evolution of this technology should have an impact on our decisional making, no?
I would submit, Your Honor, when the statute is not changed over 25 years, the answer is the statute still governs the question. It's a statutory immunity from suit. And so that statutory immunity.
So the country has to wait until we have a functioning Congress in order to deal with this again.
Well, or Your Honor, may, as you know, another way to look at a functioning Congress is unless you can get a really significant groundswell to change the law should stay as the way it is. And the courts are applying the law on publishing activity.
Well, and when I say that, I mean, there are times when in this court, an issue comes before the court and we realize that the only ones who can change it are the New York State legislature. And we make comments like this to kind of wake them up so that perhaps they'll do something about it. So again, my comment is in that spirit, that these issues that we are all grappling with, a statute that is so old and did not consider what we are dealing with now, because the developments of the technology have advanced so greatly since the enactment of this statute. I've interfered with your time. I'll give you another minute.
Thank you, Your Honor. Your Honor, did you have a question?
Yes, of course.
I haven't read all the different federal decisions that you've cited in the various circuits, but just correct me if I'm wrong. Anderson, which you called an outlier in the Third Circuit, didn't that involve a 10-year-old child who was exposed to videos that caused her to asphyxiate?
Yes, Your Honor, that is right.
So again, as Justice Mazanet-Daniel said, maybe the courts are starting to look at who the users are in this context, whereas Forrest, which you cite, and I understand why you cite to it in the Second Circuit, involved Hamas videos and the recruitment of users using or watching these Hamas videos, and the victims in that case were challenging TikTok for allowing this content, and I understand that. My point is Anderson may not necessarily be an outlier, but maybe addressing the import of CDA 230, the dealing with minors and protecting them. Wouldn't you agree?
Didn't focus on the age of the user at all, Your Honor. That wasn't the basis for the decision. The court, we submit, made a mistake of law in concluding that the algorithms that organize content somehow become the social media's own speech. That's not, no other court has found that. And in Patterson, for instance, the court specifically rejected that argument and said that First Amendment and 230 protections both apply to algorithms that sort and organize content to users. So the reason I said Anderson is an outlier is not because of the age of the user, it was because doctrinally, I submit it misread the statute. No other court, no other appellate court has held that somehow organizing content of third parties becomes.
But it's not just, or you keep saying it, just organizing it. They're not just organizing it, they're pushing it.
But,
okay, if it ends up in my feed and I didn't look up Hamas terrorists, but I'm getting Hamas terrorist videos, then that is not just organizing it. That's not just putting labels on it and putting it into categories and go look in the file box that you want. This is, I think you should look at this, and throwing it on my feed so that I am a captive audience. Well, and when it comes to children, why should there not be a different standard?
Well, Your Honor, in Shamili, the court said specifically that Section 230 applies, quote, even where the interactive service provider has an active, even aggressive role in making available content provided by others, 17 NY 3rd at 289. Aggressive role, even an aggressive role is protected by 230.
And in that case, it was an adult, not a child, right?
There's no differentiation. I agree with you, Your Honor. in that-
Every case that I've read, not one of them is focusing on the targeting of minors with regard to these algorithms. And I think that is a nuance in this case that has not been fully analyzed in any of the cases I've seen, but I suspect I've only started scratching the surface on those cases. So
But there is no case law that recognizes this differentiation in the scope of Section 230 based on the age of the user. That's not, the publishing activity is what's immune. And that's why the immunity applies. But thank you for your attention.
thank the both of you. Incredibly interesting case. All right. Robinson versus Henderson. No, someone submitted. 10839 Associates versus Big Apple. You may proceed.
Yes, good afternoon, Your Honors. My name is Donald Eng. I represent the defendant appellants in this case. This is a landlord-tenant case, basically.
So, Mr. Ang,
Yes.
if we can cut to the chase a little bit. This lease between the landlord and your client is clear that the premises were taken as is, correct?
The premises are taken as is, but still,
And the lease also makes it clear that your client would be responsible for its infrastructure, for the gas and ventilation and doing renovation. In other words, that was passed along, correct?
I think that what happened here is that there was damage to the building, which
I'm
was not
aware of the
known to us.
facts. Fire damage, I get it.
Yes.
Your client signed a lease, aware that he was taking it as is, and you're relying heavily on Barish, or that your client was constructively evicted. That's one of the
Yes, that's
claims
what-
that you're
that's-
raising, for not be liable for all that outstanding rent when you surrendered the premises. So I understand that, but the question is if you are given the premises as is and actually charged with the responsibility of creating the very condition that you claim caused the constructive eviction of your client, you don't see that that's a problem, do you?
The problem is that there was a latent defect which my client could not have known. First of all, my client didn't actually take possession until well after the lease was signed, because there was the vacate order that was issued by the fire department. We did not know.
But then he took possession and proceeded for about a year to do renovations. And that means under Barish, if the conditions were extant at the time he moved in, and he didn't immediately abandon the premises close in time to the very condition that he affected him, then you have not met one of the core aspects of being constructively evicted on this record.
Well, the reason why we make the argument is because, through the time that we vacated, there was no gas. There was never any gas. And one of the defenses, and this is, not our first affirmative defense, obviously, but one of our defenses is that we suspect that the gas could not have been turned on because Con Edison and the fire department would not have approved turning the gas back on because there was structural damage to the chimney. The chimney was damaged from the fire, which was pre-existing. It was a fire that occurred long before we signed the lease. And we wanted discovery to find out, because what happened was this, okay? Another tenant took the space, okay? Now, we were given 3 months to do renovation. The next tenant was given 6 months. I mean, why was that? It had to.
Does that matter? Under contract law, does that matter?
Well,
we are bound by the four corners of your agreement. That's all we look to.
Yes.
What contract whatever deal they cut with the next tenant has nothing to do with you.
I agree with that, but
okay.
But the reason why I raise that is because it adds to our belief that there was a latent problem which took longer to fix. which we were not aware of. The gas was never turned on. There was no inspection up to the time that we surrendered the space. But I'd like to move to the core of my argument because I want to make sure I have enough time.
You have a minute left.
All right, so the point is that when a tenant surrenders possession, the expectation is that on the date of the surrender, the guarantor is released. In fact, in the guarantee agreement, it specifically says that the guarantor is released from liability as of the date of surrender.
Counsel, but the surrender agreement says, Section 3, this agreement is without prejudice to the landlord's claim for rent, additional rent, and other amounts owing under the lease and guarantee, and your client signed it.
Well, the surrender agreement says that at the time that the surrender agreement was signed, it was without prejudice to the landlord's claims. It was also without prejudice to our defenses. Okay, I mean, this was something that was just quickly drafted, and they said, okay, you preserve your claims, we preserve our defenses. Okay, and the point that I think is very important, okay, is that there could only be one surrender date. All right, the guarantee says that you don't have a surrender date until you meet these conditions. You have to give 90 days notice, you have to have all the back rent paid up, you have to meet all these conditions, and then you have a surrender date. The surrender agreement modified the lease and modified those documents because the surrender.
And the client signed it.
Yes.
But the surrender.
So it supersedes the original lease.
And the surrender.
So you'll have time to argue on rebuttal.
Thank you.
Good afternoon, Your Honors. Jeffrey Klarsfeld for the plaintiff respondent. You're correct, Your Honor. The lease was taken, the space was taken as is. There's a representation that the tenant inspected the premises. Tenant has inspected the premises. There's a second representation. The state of any machinery or equipment on the premises and the present or future structural and physical condition of the premises or its suitability for the premises. They took knowing exactly what was there.
Now, this is on the ground floor?
This is a ground floor.
How would they know that there's damage to the chimney? And is the chimney, which I would imagine is at the top of the building, how is that part of their demised premises and not part of the structural integrity of the building itself?
The chimney was not necessarily pled in the answer. There was no specificity in the answer. It wasn't flushed out in the papers at all. Their main complaint was gas and HVAC. So the chimney was never really even discussed. It was focused primarily on the HVAC, which under the lease, the tenant was solely responsible for the maintenance and represented the inspected and took it as is. And the gas also, the tenant represented that there was no problems. There's a specific clause in the lease that says.
So he argued during his time that no amount of renovation work by his people would have remedied the problem in terms of providing gas to this was a restaurant, right? So they need the gas for cooking, would have remedied the gas provision problem because of the damage to the structural integrity of the chimney.
When they took the premises, there was a vacate order.
There was what?
There was a vacate order from the fire department at the time they took possession. There was a 2 or 3 month period where that vacate order was in effect after the lease was signed.
Did that vacate order specify that there was any issues to the chimney?
Fire damage. It was lifted 2 months into the lease term.
Okay.
That issue is not on appeal. That 2 month period is an issue of fact. That's not subject to this appeal.
Right.
They knew there was no gas when they took the premises.
Right.
They knew there was no gas thereafter. They took on the obligation to restore the gas. They couldn't get it restored, and they vacated the space and signed the surrender agreement, which clearly reserved all the rights of the parties. The claim that they reserved their defenses, yeah, they reserved defenses. They reserved the guarantor law defense. They reserved the defense that the first couple months because of the vacate order. They didn't reserve their defense that the existence of the agreement itself somehow modified the guarantee. So other than that, I rest on my papers, Your Honors.
Can those documents, I'm sorry, thank you, the language in the surrender agreement on the one hand and the guarantee and the lease on the other, can they be harmonized? Or is there necessarily did the surrender agreement necessarily sort of supersede?
It didn't supersede the lease. It worked in tandem with the lease. It said you're surrendering possession. We're reserving all our claims. It didn't say you're not responsible on an ongoing basis. In fact, the lease has many clauses where the tenant's responsible on an ongoing basis, either if the lease is terminated or if it's not terminated. That was reserved, and the defenses to it were reserved. So it goes hand in hand, and it didn't affect the guarantee at all, but it goes hand in hand with the lease.
Thank you.
Very quickly, just to follow up on that point, to the extent that the surrender agreement was inconsistent with the lease and the guarantor, the guarantee agreement, it supersedes it to the extent that, and it was, because you can't have two surrender dates. The guarantee specified you had to meet certain preconditions for there to be a surrender date. That's the definition of the surrender date. In the surrender agreement, the surrender date was the date we signed it. So the premises was surrendered, that's the surrender date. There should be no liability after the surrender date. The other point I want to raise is that, it's counterintuitive for Mr. Leung to surrender the space unless he was getting something back for it. I mean, if he's going to sign the surrender agreement, they preserve all their rights. Now we can't even operate the space. We can't make any money with the space. We're giving up the space. All the improvements he put to the space, is all lost. And now the landlord reserves all of his rights to sue. It's counterintuitive. I mean, there was a case from the first apartment, the Sandra jewel box case, which says that doesn't make sense. No, why would anybody do that? Thank you, Your Honor.
Thank you. People versus Bridget Ascencio. You may proceed.
Good afternoon, Your Honors. Brian First from the Center for Appellate Litigation for Ms. Ascencio. Counsel below was ineffective for inadvertently conceding guilt to every felony in the indictment. The only contested element of the burglary charges was criminal intent, yet defense counsel repeatedly told the jury that Ms. Ascencio's conduct constituted harassment, and in direct response to a jury question, agreed to an instruction that harassment was only a crime. That was the whole ballgame. A person who goes into a dwelling unlawfully with the intent to harass has completed burglary. So there's three things that counsel could have done here in order to not have been ineffective. First, just don't use the word harassment, right? Criminal intent is the only contested element in the case. So don't describe your client's conduct by using a word that is also a crime.
Wasn't it clear that when the jury asked the question about harassment in the first degree, that the judge was very clear in instruction to say that your client was not being charged with criminal harassment? It was very clear on that.
Correct, Your Honor, but a crime does, oh, sorry, I'm sorry.
Go on.
A crime does not need to be charged in order for it to underlie burglary, right? It does, an uncharged crime can still underlie and satisfy the criminal intent prong of burglary. The DA does not contest this.
Continue.
Okay, so the DA's position and the court's position below was that counsel had no choice but to concede that her conduct was harassment. And we submit that this is irrational, that there's no specific strategic value in using the term.
I'm trying to understand. Under what scenario is having someone who you don't really know keep coming to your office and bothering you, annoying you? You've asked them not to return, they keep doing so. Then they show up at your house with a pizza box that you didn't ask for. You get a bunch of calls, sexually explicit calls that are not wanted. Sounds like harassment to me, whether it's a criminal definition of harassment, but I think your average general person would consider that harassing. Why was that not a more than appropriate response to the lawyer had to deal with the facts he had, and he had a client who was engaging in contact with someone who didn't want that contact. So why is characterizing it in normal everyday parlance a problem?
Well, Your Honor, we're in a court of law at the time, and so the jury.
Yes, but she wasn't charged with harassment, and the judge said that. So why is that a problem?
Because it can still underlie burglary, right? And they asked, right, they knew she wasn't charged. They got all the charging documents. They knew she wasn't charged, but they still asked. So I agree that counsel had to do something, had to acknowledge the severity of the conduct. And I think that's the strategy that the court below is really saying, is like the defense lawyer had to deal with this. We don't contest that that's completely reasonable, that he had to concede the severity of her conduct. We're saying use words that aren't crimes in the penal law, right? And if you're going to use
like
crimes,
what? She wasn't nice?
No.
I mean, I'm trying to understand, how do you, because the lawyer really had to deal with an unusual fact pattern. I don't think I've seen this one before, right? And I've been around a while, right? How do you manage just unusual behavior by your client that you know the jury is going to think is bizarre, right? So how do you couch it in a way to, because it seemed like he was minimizing yeah, she was harassing her, but it's not really a crime. I mean, that's how it felt as I read it. Why am I wrong about that?
So, Your Honor, I think that there's two ways that the lawyer could have handled it. And I mean, there are words that he could use beyond nice. You know, he could say it was incredibly aggravating. It was hostile. Like the lawyer can use his creativity and a thesaurus and find a way to do it in a way that's not a crime. But if he insisted that, okay, harassment's the only word that works for me, he had to realize he's playing with fire there. That, okay, this is a crime in the penal law. And if I'm conceding this to the jury, that's the whole ballgame. So I need to at least tell the jury, when I say harassment, I don't mean the crime harassment.
So is he really conceding it? Look, I'll grant you that maybe the use of the word harassment, maybe in hindsight, he would not have done it, right? But the thrust of the defense was that the evidence didn't show that it placed the victim in reasonable fear of physical injury. And he pounded that into the jury back and forth.
But that was only for the misdemeanor stalking count, right, Your Honor? And so, but burglary was the top two charges on the indictment. So it's like he's sacrificing the two felony charges to defend against misdemeanor stalking. And so burglary, any crime can underlie it. So he just has to be more careful. And
so you're saying that just by using the word harassing, that he's conceded the crime of harassment?
He refers to it as the crime of harassment. He says he asked the jury to find that this is not burglary, but a case of harassment. He calls it extreme harassment. And so he could have corrected this. When the jury specifically asked, is harassment a crime? Alarm bells at that point should have started going. And he could have requested an instruction.
Counsel, he urged the jury to find that her actions were non-criminal, annoying, possibly, but non-criminal, not threatening to the victim, regardless of whether he said harassing or harassment. He said she's annoying, she's harassing, but she didn't commit this crime. This victim isn't scared.
Well, Your Honor, but he's explicitly telling them that he didn't use the words non-criminal, but I understand what you're saying, but he explicitly tells them over and over again that it's harassment.
But they're watching all the evidence. I mean, the evidence here is overwhelming, counsel. They're listening to the voicemail. They're watching it. He has to deal with it. So he's being very colloquial in, okay, it's harassing, a little bit of harassment, but it's non-criminal. It's annoying, but she wasn't trying to scare her.
Your Honor, it wasn't colloquial. I don't think, ultimately, even if it was colloquial, I think counsel was still ineffective. But the record, I think, is clear that counsel just didn't understand the law. He didn't understand that people did not have to specify which crime underlied burglary. And we know this because when motion counsel called him and asked him about this, he didn't say, oh, I was just speaking colloquially. He says, I think it was unconstitutional that the people did not have to specify what crime it was. And I think you should raise that on appeal. And then he's informed that actually this is well-settled law in New York State. And he says, well, I didn't do any hardcore legal research into that, right? That is the most basic law underlying this case, is what do the people need to prove for criminal intent with respect to burglary? I see my time is up.
All right, thank you.
Thank you.
May it please the court, Stephen Levy for the people. I think Your Honors hit the nail on the head with respect to the recognition that counsel was faced with a very difficult case, and he mounted a viable defense, excuse me, given the record he was faced with. He argued, look, despite the fact that there was harassment colloquially, there was just no reasonable fear of physical injury. And that's the objective heightened element required for stalking that he pounded home again and again, as Your Honor pointed out. By acknowledging that inescapable conclusion, he maintained his credibility with the jury, and he focused them on the reasonable fear element.
Yes, but you don't maintain credibility with the jury at the expense of a knockdown conviction because you've conceded one of the necessary elements, do you?
If there was a concession, Your Honor, then I would agree with you, but there was not a concession in the sense that counsel did what's fairly common among trial lawyers. He acknowledged that one element or one particular fact was satisfied, but another key fact, which was the real centerpiece of his defense, was not. So by conceding, look, there was harassment, yes, he was able to focus the jury like a laser on reasonable fear. And actually on that note, if you look at the second jury note, you can see the jury was in fact looking at reasonable fear in the context of a burglary. They were looking at stalking as a predicate for burglary. So the three charges were all linked together. This was something that was at the front of the jury's mind, and it was reasonable for counsel to keep it at the front of their mind and keep them focused on the reasonable fear element. If there are no further questions, I'll rest, Your Honor.
Thank you.
Thank you.
Your Honors, I'd just like to point out that the people's position on appeal is that the counsel was clearly speaking colloquially. I'd like to point out that in their 440 response, after spending hours and hours and hours with this material, their position was not that counsel was speaking colloquially, but that he was intentionally and strategically conceding violation harassment, right? So their claim that this was clearly colloquial.
But a violation isn't a crime, right?
Right, but I'm saying that
So that conceding a violation would not constitute ineffective assistance of counsel, right?
correct, Your Honor, but when they read our reply, they changed their position below because they realized that if we were looking at, if the choice was between was this violation harassment or was this criminal harassment, considering that he asked the court to instruct only on criminal harassment and did not ask the court to instruct on violation harassment, that he was clearly talking about criminal harassment, right? That's what counsel could have done here. Had counsel had just said to the court, please instruct on violation harassment, that would have been a legally accurate answer to the jury's question, and it would have given them a way to reconcile his repeated concessions of harassment with his supposed defense against criminal intent.
Got it.
Thank you, Your Honors.
People versus Manuel Espinosa. May proceed.
May it please the court. My name is Patrick Joyce. I represent the appellant, Manuel Espinosa, in this case. I may be wrong, and if I am, I'll be reversed on appeal. Those were the words that the trial court used at the time she decided the defendant's 30-30 motion below.
That's always true, isn't it?
I've rarely heard a trial judge say I may be wrong. In this particular case, under these particular circumstances, we're asking the court to reverse that decision, vacate the judgment, and dismiss the indictment for 3 reasons. First, this co-defendant's statement, Mr. Solano's written statement, was discoverable and was subject to the automatic discovery rules under 240.25.
Also, even if we, let's assume that we, for purposes of my question, that we agree with you that it was discoverable. Does that mean that all the time it's automatically chargeable?
Starting on May 5th, on 2023, the government, the prosecutor had a continuing obligation under Section 240.60. And
Right,
that-
but my question is, just because if we were to agree with you that that document was discoverable and clearly was not turned over timely, does that mean that whatever it was, 245 days, whatever it was, that's automatically chargeable? Isn't there a subsequent analysis that the court must then engage?
Your Honor, not in this circumstance, and I'll tell you the reason why. Under 245-60, the state is under a continuing obligation. They created the document. They created it, and it became, I think they called it an evidentiary tool. They used that tool because they were going to use it later on. They created it, and they did nothing with it. They had a duty, if the court agrees that it's discoverable, they had a continuing duty at that moment to expeditiously give it to the defense and tell the court that they have a supplemental certificate of compliance.
So that I'm clear, I want to be clear here. You are here before us solely to get this matter dismissed for that 6-month period from May of 2023 to January of 2024, when they disclosed that form, that one form, notwithstanding the thousands of pages turned over of other discoverable material, that let you or put you on notice that the co-defendant of your client was pleading the fifth, and they would use that as an evidentiary tool, to borrow your friend's words, to allow other statements into the record. Am I correct?
Your Honor, I just wanted to say it would be 8 months, not 6 months.
I'm sorry.
That's okay. But I want to focus on that for a moment because it's very instructive when the people say we gave them all kinds of documents, things that were not discoverable. It showed a tactic. This was a strategic decision on their part. There were other items that they did not believe were discoverable, but they still turned it over to the defense. This one particular item.
But again, I want to be clear in my mind. You're solely focused on May 2023 to January of 2024. Am I correct?
That's all we need. Yes, Your Honor. That's all that's needed here. And I would suggest, Your Honor, that the reason why it's the only thing we need here.
Have you abandoned all other speedy trial issues and time?
Of course not, Your Honor.
Well, I believe that's why my colleague asked the question.
I understood the question to be this: should this court remand the case to the trial division to go through an analysis on those other particular times that we think should be included and they may think should be excluded? The reason why in this case it's not necessary is 2 reasons. First of all, the period of time.
You're putting all your eggs in one basket. So I just want to make sure you understand what you're doing here, okay?
Yes.
All right. Yes. Go ahead. Pick your poison.
What I'm saying, Your Honor, is this, that especially coming from Bay, what we hear from the Court of Appeals is the court should do some type of investigation as to good faith or whether or not due diligence was required. In this particular case, those inquiries are not necessary. And the reason why they're not necessary is we know that it was a tactical decision by the state to withhold.
But how is this form Nazario material in the context of being the subject matter that you believe prejudiced you, separate from how you would have structured your defense? Do you understand what I'm saying?
No, we've moved now. It's may not be discoverable. So I answered this.
The presumption is gone.
The presumption's gone. It just disappeared. It just disappeared. So here's the reason why, Your Honor. Our position is that the statute that was in effect at that time, when it said that what was required to be turned over were statements of co-defendants, it was specifically saying all statements by co-defendants need to be turned over. That statute, and reading that statute very clearly, the subject matter aspect of the statute is first. But then the statute says, including but not limited to. And our position is the legislature was saying this co-defendant statement, this written statement by the co-defendant, because it's not just a form, it was a written statement by him, signed by him, where he was saying, if I'm called to the trial of Mr. Espinosa, that's why it has to do with the subject matter, but it doesn't even need to.
Your position is that any statement by any co-defendant, irrespective of whether it relates to the subject matter of the case or not, must be turned over.
Under these circumstances, Your Honor, I'm not
I
saying
don't understand
that.
what that means under these circumstances, because it's either all statements or just related to the subject matter.
It has to, the statute doesn't require the subject, the subject matter. But the statute says is, if a co-defendant on this particular case makes a statement as to this case, and even when the court, or when the legislature amended, they say what it has to do with the defense. This particular statement had everything to do with the defense. And I want to just move quickly, Your Honor.
How did it, all he said is, I'm going to plead the fifth. How does that translate into the defense?
Here's what I want to say, Your Honor. When this statute was introduced, it changed dramatically the discovery rules in this state. I see I'm out of time. May I finish? The reason why it changed is in the old days, the trial courts were under what the trial court had to say is, there may have been a violation, I don't know what to do. This said this: these items must be turned over because they could affect the defense, but also plea agreements, or the defendant or defense counsel's idea what to do with plea negotiations, and also whether or not there were any other defenses. In this particular situation, I don't even think the court has to go to what defense would the trial court, I was not the trial attorney, trial court have gone to, because it's very simple. Here, what this defendant has said is, I may make available to the prosecution certain statements by me not coming and me asserting my Fifth Amendment. The defense attorney should have known that on May 5th. They should have known that early.
All right, thank you.
Good afternoon, Your Honors. Jacob Marcus for the people. The Fifth Amendment form was not discoverable under Article 245 because it didn't relate to the subject matter of the case. Even though it nominally referenced defendant's case, it didn't contain any factual allegations regarding the conspiracy. It didn't contain inculpatory or exculpatory.
I like how you say nominally. It's not nominal. You had him sign the form because you wanted to be able to use that against the other defendants.
I don't know.
Come on.
I think that it certainly referenced defendant's case, but that isn't the standard that the legislature.
And so they did it just because they liked the name of the case? It had a purpose, right?
Certainly not, Your Honor. They were co-defendants that were indicted together. So that's why I think the case caption was on the top, and the substance of the co-defendant's statement, as you note, did reference the case. But the standard that the legislature has applied is related to the subject matter of defendant's case. So just referencing non-testimony is not the same as any factual allegations that relate to the conspiracy. This couldn't have been used to...
So before, I have to play devil's advocate because let's call it what it is, right? If you get a defendant to sign a form that says, I would have to assert the Fifth Amendment if called to testify, the impression that that leaves with the jury is that my co-defendants likewise have stuff that would be against their...
I don't think that's exactly right, Your Honor, and the reason for that is that it's practice, as I understand it, to have co-defendants invoke their rights outside the presence of the jury so as not to prejudice the defendant. And in this case, we didn't get to rely on the form. On confrontation grounds, Justice Neubauer said, look, you didn't give this to them in time. We're not going to let you...
I want to question you about that. The judge said you didn't give it to them in time. When would have been the proper time?
Well,
from your perspective, what was the proper time? Because clearly the judge thought that giving it to them right before jury selection wasn't the proper time. So what would have been the proper time?
Right, so because we contend it was not discoverable, the proper time that Your Honor's asking about is not contingent on the 183 days allowable under 3030.
That wasn't my question.
I think, yeah.
What is the proper time?
I think
what would have been an appropriate amount of time? Because clearly the day before trial was not the proper time. So
Yes.
what, 30 days before trial, like typical under our discovery rules?
I think it would have been I think an appropriate time would have been when they served the witness list, because the point of producing a witness list before trial is to just put everyone on the same page. This is who we're going to call, when we're going to call them, and that has to be delivered in time.
So the witness list, so now jury selection has already happened in that scenario?
No, my understanding is the witness list is served well in advance. So I think there's not a
Well
bright
in
line.
advance?
There's
20
not a
minutes
bright.
before the jury comes in? Is that well in advance?
No, Your Honor. There's
So what is well in advance? I'm asking you because if the people are permitted to not turn this over and it's not discoverable, but the day before trial is not timely, then the issue is what is timely so that the defense has an opportunity to adjust their own defense based on what they have now learned. So what is that time?
I have two answers to that, Your
Go
Honor.
ahead.
First, I think that there's not a bright line rule. It is vested in the sound discretion of the trial court. The trial court can look at the document and decide, I don't think this is exactly fair, and they have a whole cadre of tools to ensure that the trial is equitable. They could delay the trial. They could, as Justice Neubauer did here, say you can't rely on this. They could even preclude certain witness testimony, although that wouldn't have been appropriate here. So it's vested in the discretion of the trial court, and there's no bright line rule. One thing that Your Honor mentioned that I do want to touch on, though, is this form, when defense received this, the record belies their present assertion that they learned anything from this, because I'll note that defense counsel below said we were planning on objecting on confrontation grounds. So the fact that they were planning on objecting on confrontation grounds means that they understood Solano Lopez would not be in the courtroom. So I think this argument that the defendant thought Solano Lopez was going to come and testify, it's newly minted on appeal, and the record just doesn't support that. So to Your Honor's point, I think that discovery is not the only means by which a trial court is empowered to make sure that trial proceedings go fairly. And here, to Your Honor's point, to Justice Neubauer's ruling, I think the people should have disclosed this earlier, even if it wasn't discoverable, if they were intending on relying on it.
We conclude that this document was discoverable. Is that entire time period chargeable to the people?
No, it's not, Your Honor, and that's for two reasons. First, as the legislature has since codified, but as Cooperman held before, as the Court of Appeals held in Bay, the trial court has to do a holistic analysis of the people's overall.
Part of that holistic analysis, your friend just said something that's could be interpreted as very disturbing, right? You turn over thousands and thousands of documents, some of which you didn't have to turn over, but not this one.
Yeah, and I
And
think
the judge said it was untimely. I still haven't gotten over that.
yes, the trial attorney, or excuse me, the trial ADA did explain that. This is on pages 41 to 44 of the record. He says, look, that didn't strike me as discoverable. I thought it was more like an appeal waiver. These plea documents that are executed in other proceedings that I wouldn't disclose in this case. So I don't think it was the kind of conniving, scheming decision
But an
that.
appeal waiver is not something that the prosecution would want to introduce into evidence, but this form is.
Well, they
So
didn't
that,
intend.
it's totally different.
I disagree with that, Your Honor. They didn't intend to introduce this form into evidence. This
They
was
were
just,
using the form to say that Solano was unavailable, and so that his out-of-court statements could have come in.
right, just to shortcut having to bring him downstate from whichever corrections facility he was serving his
The
sentence.
shortcut so that the defense doesn't have an opportunity at confrontation.
I don't think so because, Your Honor, when Solano Lopez gets up and invokes his right, there is no opportunity for confrontation.
Yeah,
All
but
defense-
it certainly is a lot better to have them do that in front of a jury so that the jury can assess the weight of that.
Well, Your
As
Honor,
opposed to a piece of paper.
I don't think that that is true because Solano Lopez did come downstate and he did invoke his Fifth Amendment, and the trial court had them do that before bringing the jury in because there's actually, I think, pretty immense prejudice to the defendant. To bring a co-defendant in and say, I'm invoking the Fifth Amendment, wink, you all know what that means, I think would lead the jury to conclude, I see my lights on, may I continue?
Finish your sentence.
I think would actually prejudice defendant more. So that's the reason we do it outside of court. Just to return briefly to.
No more briefly, thank you.
Thank you, Your Honors.
You have a minute.
Your Honor, I want to refer specifically to, I think, Justice Schulman's question. Any period of time that could be included in 3030, we would ask this court to look at. I understand the court's suggestion, and I understand the.
It was a question, not a suggestion.
It was a question. I took it as a suggestion. Very quickly, Your Honor. This particular withholding of this particular document, both in the brief and today, the state keeps saying, this is what the defendant could have done, this is what they could have done this, they could have done that. The reality is Rosario, although this is not a Rosario case, told us very clearly, it's not the position of the court, it's clearly not the position of the prosecutor to figure out what the defense would do with something like this particular document. That's why the statute was created, so that we could have fair trials. And in order for it to have teeth, because in many jurisdictions there is no teeth to discovery, the legislature married it to 30-30. And that's the reason why this case should be dismissed. Thank you.
Seaton versus Babad.
Submitted, I think.
Oh, submitted. Sorry. Tower versus structured tone.
We're just trying to figure out which one of us goes first. It's been a long day.
Okay, I have plaintiff, defendant, structured tone.
I filed my brief first.
First,
so
okay,
I'm
and
Tao-
you are
I'm-
for Jacobson?
I'm Jacobson, so
It
I'll
doesn't
be
matter.
very
Go ahead,
brief.
that's fine.
Essentially, we're moving to say that the lower court failed to dismiss the third-party action against Jacobson. Jacobson, the plaintiff himself, Mr. Tower, was tripped over a single pipe as he was going to get some doors on behalf of Jacobson. Jacobson was retained by Structure Tone as one of the subcontractors on this site to do carpentry and drywall. And the third-party action has several causes of action, including, first of all, the common law causes of action for contribution. And as the employer, under workers' compensation, those should have been dismissed automatically. With respect to the contractual indemnification vis-a-vis Structure Tone, it's not just a mere arising out of, it's arising out of the work with acts or omissions from that specific work. And in this particular case, the plaintiff, Jacobson itself, did nothing wrong. It was the plaintiff tripped over a pipe that has ABCO's name on it. There's issues about the housekeeping of that particular pipe, which would not have inured to Jacobson. And we say that even the conditional indemnification to Structure Tone at that time from the lower court should not have been. There's no act or omission, no affirmative act by Jacobson with respect to the contractual indemnification. And in light of how the Court of Appeals is going, it seems to be narrowing this idea of acts arising out of acts and omissions. They're seeking more affirmative acts, not just merely because he's our employee. Should he be, his negligence and or his act should inure specifically to Jacobson, especially in a case where there's housekeeping issues, which would mean then Jacobson would almost be the insurer of the entire project. Very, very quickly, with respect to Structure Tone, if Structure Tone is brought back in, then their own negligence would also negate a full indemnification at this time. And lastly, as you're going to hear from everybody else, 241.6 is 1.7E. So number one, we all suggest that it's not a passageway. He was actually going into an area that was clearly going to be an office. So that would be, so E1 should not.
It could also be a work area because he had to go back and forth to get the doors.
Well, what I was going to say is E2 is specifically working areas. And the argument is that it's not an accumulation of debris.
It doesn't have to be. We've held even one item, like a hose, for example. If you trip over a hose or in this case, a pipe, that would constitute a violation of that.
Then I'm going to sit down right now. And I rely on my brief.
Thank you. And tell me who you're representing.
Good afternoon, Your Honors. I represent Plaintiff Power on this. You know, Your Honors, I read, and when this decision came down and I read it, before I reached the conclusion, I thought I won, to be honest with you, because there is paragraph in the decision that says that this pipe constitutes such scattered material, but then everything turned out to be a question of fact. So it appears to me from the reading of the decision, my excitement went away immediately when I reached the conclusion, but it's clear that that conclusion belies the findings of fact and the reasoning. And if we go beyond that, because I understand the appellate division has every right to look at the entire record and do whatever you honors please here, there's undisputed evidence that he tripped and fell on this pipe. And even if we were to assume that they are correct when they say that there is a single pipe, and the court can look at the photographs that were exchanged by them, that it was not really only a single pipe there, but it really doesn't matter because in Capuano, like Judge Schulman just pointed out earlier, it's exactly identical with this case. Plaintiff tripped and fell on a single piece of sprinkler pipe that was actually smaller than this one, and the court granted plaintiff summary judgment. And Romano, which was 2023, again, plaintiff tripped and fell on a single piece of pipe, and the court granted. So there are numerous cases that say that a single pipe is sufficient enough to warrant a granting of a summary judgment in favor of the plaintiff. So clearly the plaintiff's testimony that he tripped and fell on the pipe is not disputed by anybody. No witness. All of them are corroborated. All the accident reports that they prepared state that plaintiff tripped and fell on a single piece of pipe. All the parties have conceded, all the witnesses have conceded that the single pipe should not have been left there. It should not have been there. They've admitted that it was discarded debris. And it's clear evidence that it was not integral to the work the plaintiff was doing there because he was a carpenter and the pipe belonged to the sprinkler company. It's also undisputed that none of the sprinkler company employees were working on that floor that day based on the evidence produced by the defendants. And that's clearly, to me, satisfies E2. Even E1, I feel strongly about it, and I would urge the court to look at the record, the photograph on 474. The way he's walking, he reaches that area. He has to make a left turn, immediately look on top of a pile that is 4 feet tall, pick up a door and turn around, and he's wearing a mask. He could not see this pipe in advance because it was stuck behind the wall. When he made the left turn, he had no reason to believe that there is a pipe lying on the floor. He just went to grab the door, and as he grabbed the door and turned around, the accident happened. I will reserve whatever is left for me for the rebuttal unless your honors have questions.
You got a minute reserved. Okay.
Thank you.
Good afternoon. I have two clients, so I'm going to start with ABCO and the third-party action. Conditional contractual indemnification was granted by StructureTone, but StructureTone, in moving for summary judgment on their 200 claim, submitted an affidavit from their laborer, Brendan Corridon. And what's good for the goose is good for the gander in this situation, because Brendan Corridon's affidavit clears my client of any liability. He was on the floor at 7 a.m. inspecting as part of StructureTone's housekeeping responsibilities, and he saw that there was no pipe, there was no
pipe at 7 a.m. doesn't mean there wasn't a pipe when the plaintiff fell. So
That's
that
right.
doesn't give him a pass.
Well, that goes to StructureTone, Your Honor, not to my client. My client,
Let me see, it's your material.
it is my material,
And
but
it was left on that floor, obviously not in a safe way because a piece of it ended up on the floor.
well, the problem with that, Your Honor, is that we all agree, all of the parties agree, that ABCO was not working on the 6th floor that day.
That doesn't matter. You had material on the floor. And the record shows that some of APCO employees throughout the day were coming to that floor to get materials. So
No, Your Honor, there's no evidence of that at all. In fact, quite the opposite is true. The plaintiff, Tower, who was on the 6th floor, did not see any other workers on the floor while he was there. Mr. Corridon, while he was on the floor, he also did not see anyone there. And Leona McFadden was one of the first people to arrive.
Plaintiff falls on one of your pipes.
I agree
So
100%.
to think that there's not an issue of fact about why that pipe is there, why that pipe was on the floor in an area where workers had to traverse to get equipment, I know no case law that would let you out, but
Well, I again go back to Leona McFadden's testimony that there was gossip on the work site that actually
that there was
Tower-
what?
Gossip.
Oh, gossip, is that hearsay?
That's
And is that
just like-
reliable evidence that we have ever
That is-
relied on?
That is just
To grant
the type
summary
of
judgment?
speculation that structure tone relies on in saying that maybe somehow one ABCO employee happened to go to the 6th floor and happened after.
Is there an issue that the plaintiff fell on an APCO pipe?
No,
Okay.
there's no issue there.
That by itself keeps you in.
It's
your material.
Contractual.
You have a responsibility to keep it in a safe way.
But again, if structure tone is the very party that makes a judicial admission that no pipe was on the floor, how do they prove that my client somehow put
At
the pipe
7
on the
No
a.m.
pipe was on the floor at 7 a.m.
No, at 7 a.m. there was no pipe on the floor.
Yes.
Right. But then.
How does that mean that APCO isn't?
But structure tone made a judicial admission on this. This was their evidence that they submitted. So they got out on 200. I don't know what this court will do with respect to reversing 200, but that inures to the benefit. Their judicial admission inures to the benefit of my client, ABCO. With respect to TGA, to the extent that this court has held that a single hose is sufficient for an accumulation, what I would go back to is that in this case, 1.7E doesn't apply at all because the plaintiff actually testified that he stepped on the pipe. Not that he tripped, not that he slipped. This was his judicial admission as to how the accident occurred. All of the records.
Now, every statement is a judicial admission, okay.
I'm a big fan of judicial admissions, Your Honor.
Yeah.
I'm a huge fan. But if it's an unwitnessed accident.
That's okay, as you know from our replete case law on this issue.
Absolutely. So as I noted in the Telefan case from this department, if the plaintiff's accident is unwitnessed and he tells us how the accident occurred, well, that's the only information that we have. The accident report backs it up. Again, Leona McFadden of Structure Tone says, I wrote down what he told me.
Right.
I stepped on it, my foot broke.
See the red light?
I do.
You'll have time on rebuttal.
Okay.
Good afternoon. I'm R.M. Ehrenberg from Cornell Grace. I represent the respondent Structure Tone in this matter, and I'm the only one who was happy with the decision below. Apparently. So I actually want to focus on the 200 and saying that it was properly dismissed in this action because the court below found that this was a dangerous premises condition. It credited the affidavit from Brendan Corrigan on the morning of the accident, and we went through between 7 and 7:10 and didn't see any pipe at the time and left the floor. The accident happened 45 minutes later. The court ruled that there wasn't enough time for Structure Tone to have become aware and to have a chance to remedy it. There's no evidence that there was any actual notice, even though that had been argued. No one's ever claimed that they knew about it. Because in fact, no one knew about this condition as far as the testimony here. The plaintiff hadn't seen it beforehand, before he entered the room, which is to the extent we were saying that Jacobson, to the extent that he should have seen it, and that there's an argument to be made, and on that, then that should be imputed to Jacobson as his employer because he works for them. So that's what we believe is why there was the conditional order of indemnity, because there's issues of fact regarding, as you already noted, regarding the pipe, which with ABCO, because it's been admitted that they stored materials on the 6th floor. There was pipe, I think they're called pipe trees that they keep them on. And in fact, the testimony was that there was, in fact, when he went through, the pipes are in another office near there. And all testimony was also that even if they weren't doing work on there, they were allowed to go back and forth between the third and ninth floors. And in fact, this branch line, as we know,
So I didn't pull that out of air.
no. There was testimony that they they obviously had access to it because they had access to all the floors. And in fact, they said that the APCO workers do that because they're not necessarily, while it's better for them to keep the materials on the floor they're working on, they didn't necessarily have it.
Well, they had started work on the 6th floor. They had begun some pipe work, and the heads weren't affixed to them, so that floor actually was still a work in progress for APCO.
Correct. In fact, the marking on this for this branch line, I think it was L59, was for that space. In fact, they had the diagrams that said it had the markings to show where it was supposed to go.
And the photographs where the accident happened showed the piping and the ceiling.
Right, that exact area.
And that was storage space for piping on that area, correct?
That is correct.
So one of the contentions is they should have either kept it in the storage space or put it in a pile debris or something along those lines.
That is correct, because the Structure Tone obviously had the laborers who, there's in the testimony, go through there and do clean up, and each of the subcontractors had the responsibility to pile the debris, and as the laborers go through, as their duty is they're going through all day, and then Brendan went through in the morning, and that's what the testimony was.
Thank you.
Thank you.
All right, well, here, you have your rebuttal time.
So I just want to go back to TGA. Again, the accident occurred because the plaintiff stepped on as opposed to tripped or slipped.
He stepped on it as he's carrying in a door.
Yes, because he says, I stepped on it and my foot immediately broke. This is not a situation where like he injures his hands because he trips and he falls.
He has the door.
Yeah.
So he can't.
Right, but
the
then,
door.
he says, when according to the ambulance report, he says patient states, while at work lifting a steel door, it fell, causing injury to the foot. When he was asked at deposition, did you say that to the EMT? He said, yes, if that's what's written there, I did say that. So this is his testimony. Now, in terms of 1.7, if you slip, you can't allege E. And if you trip, you can't allege D. So in this case, because he's saying he stepped on it, this is not the result of either a trip or a slip.
I'm not even sure how one would describe if you put your foot on top of a pipe, which I'm assuming is round, right?
He said it broke.
So either your foot slips forward or
again.
My point is that on a piece of pipe, it's hard to say one would slip or trip unless you the pipe is affixed and you literally trip over it. That's not what happened here. That's not what he describes.
No,
right?
he describes that he stepped on it, and when asked for clarification at his deposition whether he slipped, he said, no, I didn't slip. I stepped on it.
Okay.
So I think that distinguishes.
And his foot broke, right?
And his
So we know that there's a broken foot and there's a pipe on the floor.
Yes, but how did the pipe get there, Your Honor?
Yeah.
Yeah.
That's the question. And that's what the jury will likely have to figure out.
Thank you, Your Honor.
You have 2 minutes.
No, I did not.
No, you don't have rebuttal. No, you didn't ask for it. Yeah, you have rebuttal time.
Your Honor, let me first address this story about his testimony that he slipped, because this is news to me. If you look at the record, page 161, question, at the time of the accident, were you moving anything, carrying anything, something else? Answer, no, I was carrying the door. You mean when I tripped? Plaintiff responded to the question with the word, you mean when I tripped? Next question, how did your accident happen after you picked up the door? Answer, picked up the door off the pile, turned to walk away with it. When I took the first step, I felt something under my foot, stumbled and fell down. Question, You said it was one step until you slipped on the pipe? Answer, one step with my left foot, tripped over something. At the time, I didn't know it was a pipe. I knew I tripped over something. This is the testimony of the plaintiff. So I'm very surprised because I was there, I did the deposition, and I was shocked when I heard this argument. The plaintiff did not trip. And when you look at all their accident reports, they list the cause of the accident, plaintiff tripped on a pipe. So everything on the record is clear about plaintiff having tripped on the pipe. And I don't know about the ambulance call report and what was written there and who wrote there. I think there are rules of evidence that you need to get that in a different way, but we don't really need to get there because his testimony directly contradicts what they're arguing in front of this court. As far as the Section 200, it's the only puzzling thing with the affidavit of Corridon, and this, the one that TGA is so strongly embracing now and saying that, no, APCO is embracing that affidavit and saying that, hey, we are exonerated because he didn't see it. The truth of the matter is that McFadden never, the first witness of structure tone, never testified that there was any inspection of the floor area done on the morning of the day of the accident. The other witness that structure produced, Crawford, never said that there was an inspection of the area done in the morning. All the testimony was that the inspection was done the night before. This affidavit was sneaked in for the first time as part of the summary judgment motion under 200 to say that somebody inspected the area 1 hour before the accident. So, you know, I know that the record is what it is, but if you want to see beneath the record, then one might wonder why we didn't know about this key witness until the motion for summary judgment was filed, because he's a key witness in terms of notice and saying that I inspected the area 1 hour before. That's all I have to say. Sorry that I think I surpassed my time.
Thank you.
Thank you, Your Honor.
Thank you all. Infant versus Paulino. You may proceed.
Good afternoon, Your Honors. Carrie Wareheim on behalf of the defendants' appellants from Scahill Law Group. I just would like to just draw the court's attention to two portions of Judge Alpert's order that the defendants find issue with. One is the portion of the order where the court finds that an issue of fact was raised based upon the plaintiff's submission of the May 2019 311 complaint. We find issue with that based on the fact that the plaintiff in her affidavit does not indicate she does not indicate that the defendant in any way received notice of that 311 complaint when it was made in May. And in fact, the defendant's testimony back on record page 146, he indicates that he did receive prior 311 notifications, but none of them were about bed bugs. So the plaintiff submits a 311 complaint, but in her affidavit, she merely states that it was my impression that 311 would notify the landlord, but there was no proof that the landlord was in fact notified. So it's our position that the mere submission of the May 2019 311 complaint was insufficient to raise an issue of fact in and of itself. The second part of Judge Alpert's decision was that he indicates that the defendant did not state unequivocally at his deposition that he checked the HPD website for complaints against his property. Now, again, we would indicate that this is not a burden. This is not a burden that a defendant has, that at least I haven't been able to find in any of the First Department case law, that in order for a defendant to prove that he did not have notice of a dangerous condition in a negligence case, that he's required to check HPD complaints against his property. He's required to testify as to whether he received any complaints, whether there's any type of notice.
Through HPD doesn't count?
HPD complaints count, for example, in this case, if a violation was issued. But and he was specifically asked, you know, did you receive any 311 complaints? And he testified, honestly, I received 311 complaints and violations regarding, I believe he said, mice and roaches. But in this case, there was none about bed bugs. but there's no case law requiring a property owner to check HPD complaints in perpetuity against a property to prove that a dangerous condition doesn't exist. At least I haven't been able to find one in this department.
Okay.
Thank you, Your Honors.
Thank you, Your Honors. May it please the court, Beth Gehrig for the plaintiff respondent. Regardless of the 311 complaint, which we believe is enough to raise credibility issues on the issue of notice, we also have plaintiff's own testimony. And we have plaintiff's testimony on page 91 of the record and 92 of the record and 93 of the record that she complained to Pedro. What we have here is a tip.
Complain to
The owner.
the owner.
What we have here is a he said, she said situation. And when you have he said, she said, and the burden is on the party who's moving for summary judgment, who is the defendant, credibility issues go to the jury. The facts are to be weighed in the light most favorable to the non-moving party. All the standard summary judgment language, we believe the court here got it right. We believe that the court correctly noted that they did not make their prima facie burden, and as a result, it didn't even come to the plaintiff to raise an issue of fact in opposition. Unless you have any questions for me, I'm comfortable resting on my brief.
No questions, thank you. You have a minute on rebuttal?
But just real quickly, record page 103 to page 104, the plaintiff was specifically asked, did you make any complaints to the landlord prior to July 2019 about any complaints about the bed bugs? The plaintiff specifically answered no. Thank you, Your Honors.
Thank you. People versus Baron Spruill. Do we have a prosecutor here?
My adversary is downstairs. Can I run?
Yes, sure.
Yeah, I'll be back. You can go ahead if the court's ready. I don't know.
No, I can't without the other side.
Okay.
I don't, I hate doing this to you, but unless, okay. Counsel, you gotta keep an eye on the monitor downstairs so you're in here. You may proceed.
Thank you, Your Honors. Maya Kwasi from Arnold and Porter Case Schroller on behalf of Defendant Appellate Baron Spruill. May it please the court. So I'd like to focus on the constructive amendment argument as it raises fair notice concerns. So the grand jury in this case handed down an indictment based on one theory, that Mr. Spruill caused the death of the decedent by shooting. The people tried this case from start to finish on that theory, and then they rested. And then on the eve of summations, the people requested jury instructions on a brand new theory, that another participant caused the death of the decedent.
Well, there were 3 people who were a part of this alleged crime, right? It wasn't just your client. There were 3 participants in this case. So why was that not fair game and implicit in the indictment of all 3?
Your Honor, because the people did not present a case that, I think you're speaking to the accomplice liability point. The people did not present a case on accomplice liability. There's evidence in the record that one could retroactively reconstruct to support an accomplice liability theory, but speculation is different than facts that are proven beyond a reasonable doubt, meeting the people's constitutional mandate of a burden. That's because there's evidence in the record that there were multiple men in the stairwell, as you say. There's evidence that more than one gun was discharged. There's evidence that one of the other unapprehended individuals may or may not have had a gun, but sort of these facts that go to speculation to support an accomplice liability theory are entirely distinct.
Why is that speculation? You just said that the evidence shows that there were 2 guns. The evidence shows that there were multiple people in the stairwell when this shootout occurred. So I don't understand what is so far-fetched about an accomplice liability here that was charged, right? It was presented to the grand jury as a multiple party event.
So let's talk about inferences. So there's facts that can be proven to support an inference that another participant shot the decedent. That could be an unapprehended individual, eyewitness saying that an unapprehended individual stood over the decedent but didn't see the shooting but saw a smoking gun. There's an inference that the jury could glean from that other individual shot the decedent. That's entirely distinct from loose inferences that are merely speculative, such as multiple men in the stairwell. That's not enough to indicate, to meet the people's burden of proof beyond a reasonable doubt, as they're mandated to show that one of those individuals affirmatively shot the decedent. What we have here is a felony murder charge, right? And there are certain...
If I could just stop you for a second, does the People versus Rivera, does that court's statement that there's no material distinction between principal and accomplice liability, does that undercut your position?
It doesn't, because in People v. Rivera, the people affirmatively put on an accomplice liability case. Here, the people did not. There was no affirmative case. It was, of course, absent from the indictment, and there was no eyewitness testimony. There was no affirmative ballistic testimony that indicated that, for example, more than one bullet was found, and more than one bullet from more than one gun was found in the decedent, indicating that multiple people were shooting at the decedent at the same time. What we need is evidence that meets the people's burden of proof beyond a reasonable doubt that there were multiple shooters. But we have, for example, the star witness's testimony that there may or may not have been another, one of the unapprehended individuals with a gun. And that may or may not is not sufficient. We see that in People v. Ortiz, for example, where there was an individual who was charged with unlawful entry. And there was a 911 call where there were, a 911 caller said that there may or may not have been another individual. And the trial court instructed on the accomplice liability theory, and it was overturned by this court, by the First Department, because that's not sufficient. There's the case law recognizes a difference between speculative facts in the record versus proof beyond a reasonable doubt. And the trial court recognized this as well when they instructed the jury. You can see on page 860 at 18 through 24, the trial court says, an inference, though, must only be drawn from a proven fact or facts, and then only if the inference flows naturally and reasonably and logically from facts proven or facts not if it is speculative. So this distinction between facts that are speculative in the record that one could retroactively construe and point to and say, oh, this could, reasonably support an accomplice liability theory is entirely distinct from the people affirmatively putting on a case of accomplice liability. And that did not happen here. In fact, the people said during summations, one point said, it's possible that someone was firing from the stairwell. So even the people during summations were loosely trying to tie together this notion that an accomplice liability theory could work. And it's important to keep in mind that if Mr. Spruill was merely an accomplice, we need to know who the principal was, not by name, but we need to be able to identify the person in some capacity, whether it be by eyewitness testimony, affirmative ballistic evidence. It's not sufficient to say that there were just multiple men in the stairwell. There needs to be evidence tying these multiple men to have actually shot at the decedent in some fashion, and we don't have that here.
All three of them had to shoot at the decedent?
Not all three, but one.
It was enough, right, that if all three of them went there together for the purpose of shooting him, whichever one had the intent to shoot him, it doesn't matter which one shot him. If all three of them went there, knowing that that was the intent of one of the participants, that's enough, right?
May I respond to your question? No, respectfully, no.
That's not enough.
What is
That's not enough. I go with Martin to go shoot Tom. Martin knows that I'm going to shoot Tom. Martin comes with me. He's not liable to?
That would be sufficient if one of the
How is that different from this scenario that was pled in the indictment that three people went and had this confrontation with this gentleman?
Because the only eyewitness testimony identifying a shooter said that Mr. Spruill shot at the decedent. There was no other testimony that identified any other shooter. there was no other evidence that supported that multiple individuals shot at the decedent, whether it be ballistic evidence of.
That's not what I said, but okay. You'll have time on rebuttal.
Good afternoon, Your Honors, and may it please the Court. ADA Josh Weiss for the people. Justices, there was no constructive amendment of the indictment in this case. Defendant was charged, and the jury convicted him of second-degree felony murder under New York law.
The indictment has the defendant as the shooter, correct?
Correct, Your Honor.
And that's not, is that the theory that you proceeded on at trial?
The people certainly argue that the defendant had shot the victim, but before the grand jury, the people never limited themselves to the theory that defendant fired the fatal blow. By the express terms of the felony murder statute, causation is defined to include a death caused by either the defendant or a participant. And here, that exact instruction was given to the grand jury. So both that instruction and the trial court's instruction track the definition of the felony murder statute.
I take it that your position is that People versus Rivera, that my colleague referenced before, that's on point and controls here.
Yes, in fact, Your Honor, I believe that we don't even need to reach Rivera. I mean, it certainly reinforces our position here, but the statute, it renders any distinction immaterial, any distinction between accomplice and principal liability immaterial by its express terms, because liability attaches whether the defendant or a participant causes death. It's embedded into the text of the statute itself. And here, the defendant had ample notice based on Mr. De La Cruz's testimony before the grand jury and the ballistics evidence that the defendant went to the scene with accomplices and that one of the accomplices also brandished a firearm. My opponent suggests that Mr. De La Cruz prevaricated at trial as to whether there was a second gun. In fact, Mr. De La Cruz was unwavering about the existence of a second gunman, and that detail was corroborated by the ballistics evidence. And consequently, the trial judge properly determined that a reasonable view of the evidence supported defendant's liability, whether he fired the fatal shot or an accomplice fired the fatal shot. I'm happy to address any other points that my opponent raised. If not, and Your Honors don't have any questions, we would just ask you to affirm.
Thank you.
Thank you.
Notice is derived from the indictment, and the indictment had one specific theory as to felony murder, which was that Mr. Spruill caused the death of the decedent by shooting the decedent. That is one theory under felony murder. It's true that another theory is available under felony murder, meaning that another participant could have shot at, in this case, shot at the decedent. But systematically applying the entire text of a statute in a case without considering the actual facts that were admitted into evidence is improper, and in this case, is unconstitutional and violates fair notice, because what matters is what the people's case was. What did they affirmatively present? What was their theory as represented in the indictment and the evidence admitted at trial? You can't just systematically utilize a statute, all the text of a statute that contemplates alternative theories for the prosecution to consider. So that's one important point. The complete definition being used here is not an argument that wins the day, because you can't systematically just use the complete definition of a statute. And I think it's important here to keep in mind, like occurred in People v. Grega, the fair notice issue really hits home here, because we don't know what the jury hung their hat on in terms of convicting Mr. Spruill. Did they use that he affirmatively shot at the decedent, or did they use another participant jury charge? And that's a problem, because there isn't evidence in the record to support this another participant charge. There isn't evidence that meets the people's burden. And because we can't disaggregate for certain, like occurred in People v. Grega, we knew for certain that the jury did not use the wrongful instruction. And so that's why,
You can finish your thought.
and so that's why the case was affirmed, but here there's no way to disaggregate. And because we can't disaggregate, the constitutional issue stands, and there was a fair notice violation here.
Thank you. I believe you're pro bono counsel here?
Yes.
The court wants to thank you and your firm for your dedicated pro bono service on behalf of this defendant.
Thank you very much.
Minkx versus Mount Sinai Health System. You may proceed.
Good afternoon. May it please the court. Patrick Lawless for the defendant appellant Mount Sinai. The Supreme Court improvidently exercised its discretion in granting the plaintiff's motion to vacate the default. The court even acknowledged that the plaintiff failed to provide a reasonable excuse for the failure to appear at the conference, or less than compelling excuse. But more importantly, the plaintiff failed to demonstrate a meritorious cause of action. The affidavit submitted by the plaintiff's expert is woefully short. It just contains conclusory statements, doesn't identify what the departures were, doesn't connect the departures to the alleged injury, and therefore the motion should have been denied.
Sir, are we a little more lenient on motions to vacate with respect to the sufficiency of an expert's affidavit than we are, say, at summary judgment?
Yes, but it doesn't mean that it can just be entirely conclusory and devoid of any connection, and especially in a med-mal case, that any connection to the injury, any description of what the deviation from the standard was. This court set forth in the Caramonte case, which is cited in our brief, what is necessary in this type of affidavit, what needs to be included, and it certainly wasn't included in this case. If there's no other questions.
You'll have
I'll
time
just
on
submit.
rebuttal.
Yep, thank you.
Good afternoon, Your Honor. My name is Cheryl Minkx. Minkx Law Firm. I'm plaintiff pro se in this matter. I am a personal injury attorney. I've been practicing for 35 years. This was a simple conditional order dismissing it without prejudice to renew upon an affidavit of merit and a reasonable excuse.
And what was the reasonable excuse?
The defendants produced no discovery. I had made a motion to strike their answer. Everything was
That's not a reasonable
No,
excuse.
no, no,
for your, I'm talking.
Sorry, Your Honor.
That's not a reasonable excuse for your failure to appear, and then your failure to respond to the court when the court called and asked you to get on the virtual call. Explain to me why you felt you had the right to say no to the court.
No, I didn't feel I had the right to say no to the
Well,
court.
you didn't get on the call.
I'm very respectful of the court. I was not.
You didn't get on the call.
I was in the subway because I thought, because the motion and the conference had been adjourned at least 6 times previously.
The question that your staff member asked the judge, when the judge asked for you to get on the call, was, the lawyer wants to know what this is concerning.
I did not know that there was a conference that day. I thought the motion, the defendants had asked.
Are you telling me that your secretary or whatever staff person you were dealing with didn't tell you that the judge was on the phone? Is that what, I need an answer to that question. Did your secretary or staff person, whoever it is, I don't know who that person is, did that person tell you the court is on the phone?
They probably did not tell me the judge was on the phone, but however, I was in the subway, and the minute I got back to my office, I called the part. I called them up. I thought, since the conference had been adjourned by the request of the defendants at least 6 times, and then they asked for the motion to be adjourned with a conference, I thought that since the motion was adjourned out to sometime in August, I thought the conference had been adjourned too. That was the reasonablest mistake I made. It was not a first time on. This issue had been adjourned at the request of the defendants at least 6 previous times. It was adjourned, 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 adjourned. And then the defendants asked, can the motion and the conference be of the same date? And That's what I thought was happening, and then it was adjourned. The conference was not adjourned, the motion was adjourned. So I thought the conference was adjourned at the time of the motion. I am very respectful of the court.
Counsel, when your staff member informed you there was a phone call and that you were wanted, when you communicated, what is this query about? You did do that. You don't deny
I
that.
called the court the minute I got into my
No.
office.
But you were able to speak to your staff, right?
We texted. It was a text.
Well, would you tell your staff to let the court know that you were stuck on the subway, or was this all born of an afterthought?
I really, honestly, I don't remember the exact details. All I remember is that the minute I knew that the court was calling me, I got on the phone to the court because that's the way I operate. That's important to me. I was not disregarding the
You wish to
court.
be heard on how your expert affidavit is sufficient?
Yes, I do. The expert affidavit, there have been no depositions held in this matter yet.
That doesn't matter.
Well, according
Does
to
the counsel, on a medical malpractice case, you need an expert affidavit to establish the standard and the deviation? Tell me how that has been satisfied with your expert's affidavit.
Well, may I just say, in Dyer v. SUS, decided by this court, they held that the expert does not have to go into this court held that the expert does not have to go into the details where depositions have not yet been held. My expert opined, did 7,000 of these operations. He opined to a reasonable degree of medical certainty that the loss of 25% of my femoral nerve and the atrophy of my quadriceps was due to the hip replacement surgery. Once the depositions are held, there can be more specifics as to what the deviations, the specific deviations of the standard of care are.
I'm sorry, this sounds more like a conclusion. I don't see the connection of the dots in terms of how the surgery caused the nerve damage.
Well, the femoral nerve is right underneath.
No, I know what the femoral nerve is,
Yeah.
but I would need to know, well, the surgeon did X, and when he did X, you don't need a whole megillah, but you need something there. It's a conclusion.
Well, my expert did say that as a result of the surgery, the femoral nerve was damaged. I mean, anything else would be rank speculation. If he said the doctor did this, the doctor did that, it's speculation until the doctor testifies as to exactly what he did. But he does know this is a very rare result of a hip replacement surgery, and it can only be because the incision is right on top of the femoral nerve. So there was femoral nerve damage, which I'm still bearing for the rest of my life. I can't climb stairs, I can't run, I can't put on my clothing in the morning. I have to lift my leg up to put on my clothing. So actually, the case law from this court says that if depositions have not yet been held, the affidavit of merit does not have to go into the specifics of what the doctor did because
You have to establish a departure.
Well,
you still must establish a departure, but we have your brief and your record.
Okay.
Counsel, you have time on rebuttal.
I'd just like to point out, again, that the affidavit of the expert was completely devoid of anything other than conclusory assertions, and he does state in his affidavit that he reviewed the medical records. So at the very least, he would have been able to establish what was done, what the deviation was, how the deviation caused the alleged injury, but he
Isn't
didn't
there
do any of
something
that.
called an operative report?
I'm sorry?
Isn't there something called an operative report?
Yes.
And that usually spells out from the inception of the very first cut all the way to the very end exactly what was done.
Exactly.
So we could have read that and said ABC, correct?
Exactly. Thank you.
Thank you. Style versus Sea Air Customhouse.
Good afternoon, Your Honors. May it please the court. Yvette Sutton, Lazarus and Lazarus PC, on behalf of the plaintiff appellant respondent Claire Marie Style, as the personal representative of the estate of Salvador J. Style. I'm appearing on 3 separate appeals. Plaintiff's main appeal from the December 15th, 2023 summary judgment order, in opposition to defendant's cross appeal on the summary
I
judgment.
suggest you get to the heart of the argument. If
Order.
you go through all of that, you're going to eat up 2 minutes of your time.
I'm just going to make 3 points. I know the court is familiar with these matters. I'm going to make 3 points. It has now been almost 6 years. Salvador J. Style passed away in April of 2020, and plaintiff is still without her shares and any knowledge of what her shares, what those shares carry. 6 years. And this is due to defendant's many procedural roadblocks.
Settlement agreement did not extinguish Mr. Stiles as a shareholder of this company, correct?
That's correct.
And there's nothing in that settlement agreement that cancels out his shares at the time of his death, correct?
That is correct, and that is exactly what this court held in the 2022 decision. And this court held that plaintiff, it does not say a transfer causes Stiles shares to disappear or revert back to
it's ambiguous what the transfer is. In the earlier appeal,
correct.
this court determined that the transfer in this agreement is ambiguous to determine whether a transfer by operation of law fits within the intent of the parties here, correct?
That is correct, Your Honor, and plaintiffs maintain that it is ambiguous and it was unclear and it was improper.
This court already said that.
Yes, and it was improper for the for the Supreme Court to determine that as a matter of law on summary judgment.
So would it be your view that seeking discovery, which is what you've sought here to determine where your shares are, right? That would not necessarily run afoul of the agreement, correct?
That is correct. That is also part of the discovery appeals, which are subject to discussion as well today, that we're entitled to discovery in this action to determine what the financial status is of the companies, what the shares are worth. And that's something that, while we are not entitled to a books and records inspection, we are entitled to discovery in the underlying action. I just want to point out 2 other quick points. In the original brief that was filed on the motion to dismiss, and sort of contradictory to defendant's position on the summary judgment briefing, defendants recited, and it's at record 405 and footnote 100, plaintiff has not indicated in these proceedings whether it has in fact agreed in writing to be bound by the settlement agreement. To the extent plaintiff has not done so, the court maintains continuing jurisdiction pursuant to paragraph 13 of the settlement agreement to order plaintiff to promptly deliver such writing to defendants. Alternatively, the court should find that plaintiff, as a putative successor to Mr. Stiles' C.R. shares, has constructively bound itself to the terms of the surrender provisions. This does not speak in terms of a dismissal of the action because she has not executed any transfer agreement, which may or may not be applicable. The Supreme Court was improperly dismissed.
Has one been offered to her after this court's last decision?
Sorry, well,
Has the agreement she needs to sign according to the settlement agreement been offered to her to sign following this court's decision?
Not pending the summary judgment decision. And after the summary judgment decision, it was only offered with strings attached that the appeal be dismissed.
Okay.
Thank you, Your Honor.
Thank you. Counsel?
May it please the court. Good evening. I'm John Chun from Herrick Feinstein. As the court aptly noted, we've heard these arguments before. We were here in 2022. We were in front of you, Justice Shulman, on that panel. And what the court held was that, pursuant to the settlement agreement, plaintiff had surrendered her rights because she stood in the shoes of her husband, her deceased husband, and therefore, as the state representative, was bound by the settlement agreement, under which she agreed, and he agreed, that they would no longer interfere with the Sierra companies. They would part ways forever. Because, Your Honor, just to bring you back to the context.
Wait. Where does it say that they would part ways forever?
Your Honor, because
the only clause that I saw that said anything like that was in the event of a sale or a transfer. in his lifetime.
Correct. The share,
Okay.
and so on, Your Honor, going to your question, I believe you're correct. The settlement agreement didn't extinguish the shares. It didn't cancel the shares.
Right.
In fact, we did not argue that in 2022. But as this court aptly noted, there was a transfer agreement provision that said if you transfer the shares, the transferee must agree to be bound by the surrender provisions in the settlement agreement. And what the court said was we can't decide in 2022 without discovery whether that transfer provision also applies to transfers by operation of law, the passage of the shares from the decedent, Mr. Stile, to the estate, the personal representative. Your Honor, when we went back to Justice Engeron in the trial court, we argued to Justice Engeron, we believe this can be decided on the contract face alone. Because if you look at
Notwithstanding this court's decision.
Well, we gave both. We gave Justice Engeron both options. We said the court said it's that it may be, and the court said it's unclear, but we believe that on its face, if you looked at the surrounding provisions, because all of the benefit provisions talked about, well, you get payments
So
until you
again,
die. Yeah.
so again, you encourage the judge below to ignore this court's determination and reach the determination on his own because he has the authority to overrule this court?
No, Your Honor, I would
Oh,
never,
I didn't think
ever
so.
tell
I didn't
a
think
lower court
so.
judge to ignore what the first department had ordered. But I did give the judge our arguments as best as I could present them.
Right, so the same arguments that my colleagues heard and rejected, you reiterated for the judge below and had him give you the same.
Your Honor, if Your Honor believes that was me asking the judge to do.
I don't know who argued below. This isn't personal, counsel. I'm
Thank you.
arguing like,
Because
I'm asking questions like you're arguing.
That is so contrary to anything that I would ever ask a lower court to do. But I also took into account that also this could arguably be ambiguous, and so I offered Justice Engeron the deposition testimony of the drafters of the agreement. One of the drafters is now a federal judge, Judge Halpern, and the other drafter was a lawyer that represented Mr. Stile. Judge Halpern said the point of this transfer agreement was to apply to transfers by operation of law.
No, that's not what he said.
Those aren't his exact words.
No, that's not what he said. He said, we were concerned about transfers to the sons during the lifetime of Mr. Stiles. That he surmised, the judge surmised, that Mr. Stiles wasn't even considering and contemplating his own death in the making of this settlement agreement. That really wasn't what was at play here.
Your Honor, this is what Judge Halpern said. He said that the
Because I read it wrong, so please read it.
Your Honor, I would. All I can provide to you is what I have in the record as Judge Halpern's testimony. The transfer agreement provisions were intended to apply to Stiles Sr. and his successors, irrespective of how the transfer or disposition occurs, by agreement or by operation of law or even by death. And he said that in a number of...
He said a lot of other things, right? Everything I said to you earlier, he also said. There is, I will go back to it because I know I am not misstating what I read.
Yes, Your Honor. Your Honor, the other point that also gets brought up by opposing counsel is Stiles Sr. did not want to sell his shares. He wanted to keep them because there was so much acrimony, he wanted to keep them. So Judge Halpern did the best he could as a drafter. He was like, these people have been at each other's throats for years, lawsuit after lawsuit. I need to figure out a way to end these lawsuits. And so the best way I know how, with Stiles Sr. is not willing to give up his shares, is to create a settlement agreement that maximizes all of the surrender provisions and then insert a transfer clause that says when these shares get transferred to the estate, when you die, by operation of law, whatever, that transferee will have to sign a transfer agreement and agree to be bound by the settlement agreement in order to take over. And Your Honor, that made perfect sense.
In order to take over?
In order to take these shares.
So I'm going to ask you something silly. So then why couldn't you acknowledge Mrs. Stiles as the successor owner of the shares and avoid all this?
Your Honor,
If that is what Judge Halpern said, I mean, right, why don't you just say, okay, we acknowledge you as the shareholder and sit down with her after his death and avoid her having to seek a declaration because our order allows the declaratory judgment action to move forward after all this Sturm and Drang to allow her to determine whether she's the one-third owner of the company.
yes, sir. And so that's where the transferee agreement comes in. We didn't attach any strings to a transferee agreement. We did, when they did approach us during the pendency of this appeal about sending them over a transfer agreement, we said, wait, you have this appeal going on. How is this consistent? Call me, and so let's discuss. We never heard from them again. As opposing counsel said, they chose to pursue this appeal. And Your Honors,
Is that not their right?
Of course, it's their right, Your Honor.
And is there, on what basis, because they have an appeal, should your side not provide the very transfer agreement that you have been pounding into the ground that they have to sign?
Your Honors, first of all, we did not ever refuse to give them a transferee agreement. We want to set up a call to discuss all of that because, Your Honor, there is a view of the world, and I want to present myself as being cooperative to try to get this resolved. There is a world in which they're the assignee or the transferee. They should come to us with the transfer agreement they want us to sign. But I was willing to have that discussion. It was never had because they never picked up the phone. And one of the cases we cited in our papers is the MacLeod decision in the opposition to the motion preliminary injunction. In that decision, the court held that actually it's the transferee who should provide the agreement to the party that they want to have executed. But we weren't standing on ceremony, Your Honor. We were not engaged in sort of a finger pointing, you do it, you do it. We just never even had the conversation. And under the CBRA, so what is the estate's status right now? They're not a shareholder because they haven't yet signed the transferee agreement. Right now, and according to this court's recent decision in 2022 in the Seabrow matter, right now, until that transferee agreement gets signed and the shares are actually transferred, the two remaining shareholders, Mr. Antico and the estate of Mr. Hyde. Mr. Hyde unfortunately died during the middle of this litigation. That's how long this thing has been going on. They're currently 50-50 shareholders until that transferee agreement gets signed. So we're not saying the shares have disappeared. We're not saying the shares have canceled. But following this court's law, they are 50-50 shareholders because the transferee has not yet done what she needs to do to be recognized as a shareholder.
Where in any of the documents of this corporation, of this company, and the agreement between the shareholders, and in that settlement agreement, does it say that you forfeit your shares if the transfer agreement is not signed? Is that anywhere in the settlement agreement?
No, Your Honor, and we have not said that the shares have been forwarded. We're following the
I'm
Seabrow
just trying
decision.
to understand how you get to I'm 50-50 when there's nothing in the settlement agreement that extinguishes those 33% shares, but.
And we are following the instructions of this court in the Seabrow decision for that purpose.
Counsel, you have time.
Thank you, Your Honor. Just another few quick points. The 2022 decision of this court provided that plaintiffs should be given the opportunity to execute such a writing, the transferee agreement, if it is applicable to transfers by operation of law, not that the case gets dismissed, as it did by the summary judgment decision. And so to the extent that a transfer agreement is required, it should not be that the case is dismissed and then we sign a transfer agreement and are back in court to determine what rights and liabilities are the responsibility of each party, which is what the defendants would like us to do here. Thank you, Your Honors.
Thank you.